Hello, sir. I would like to mention item number 19 on behalf of Titapak.
Will you have a level now?
Lordship, we have consent, consent from
Mr. Adjournment advocate.
Lordship. I have been instruct my senior.
Don't take it otherwise.
Yes, sir.
On lighter note. Item
19, Lordship. Okay.
Titapak.
Yes, Lordship.
On the prayer of Mr.
B. Sibo.
B. Sibo. Learned counsel appearing on behalf of Mr. Titapak, learned counsel for the appellant. On the ground that Mr. Titapak has some personal difficulty today. Prays for adjournment of the matter. Praise the Lord. This the matter after 3 weeks.
Yes, Lordship.
Mr. Lordship, I am requesting for listing a criminal appeal on 27/8/2026. Lordship.
Why?
27.
Why?
Because I am not able to appear before this court on last occasion. I am not able to appear before this court on last occasion, 2 occasions. Lordship. Matter is urgent.
27 not possible. When is supposed to be listed?
Orders
When is supposed to be listed?
27/8.
Huh?
27/8.
No, you are seeking for 70. You are asking for 27.
Yes.
When it is likely to be listed?
Likely to be
As per the
listed on last occasion, it is 11/8. Lordship. 2 weeks.
For orders?
Yes, Lordship. Lordship.
May I, my lords?
Yeah.
I'd like to mention item number 18, my lord. And I'm for the informant in this case, my lord. And the conducting counsel is due to some personal difficulties is out of station, my lord. So matter may be fixed up to 2 weeks, my lord.
Okay.
These two. Okay.
On the prayer of Mr.
See COVID, my lord.
C. COVID.
Yes, my lord.
Don't frighten us. C. COVID.
Yes, my lord.
Learned counsel appearing on behalf of Mr.
With
Mr.
C. Ex Gauhati.
Ex Gauhati. Learned counsel for the respondent number 2. And the prayer not being objected to by MSSB direct. Learned counsel for the appellant. Let this matter be listed up to 2 weeks.
2 weeks. Much obliged.
May I, Your Lordship? I beg to mention item number 12. On behalf of leading counsel B. Picha for respondent number 1, 2, 3. Your Lordship, leading counsel is not available due to
Your Lordship, I have an objection, Lordship. This Lordship,
due to regular medical checkup. Your Lordship.
IA is for what?
delay condemnation.
What is the delay? What is the
82
delay?
days, Lordship. 82 days of delay, Lordship.
Your Lordship, this will be the last.
And Lordship, this I is pending for more than a year, Lordship. And they have already filed their objection, Lordship.
We'll consider what's there.
Your Lordship, this will be the last adjournment. Your Lordship.
Last occasion also, Lordship.
Then 27?
Your Lordship, 1 week, preferably on 3rd September, Your Lordship.
Anyway,
Last-
is in on medical under medical treatment. Medical treatment.
Yes.
On the ground that Mr. B. Picha learned counsel for the respondent.
1 to 3 years.
Respondent 1, 2, 3. Is under medical treatment. Mr.
G. Taipodia.
G.
Taipodia.
Learned counsel appearing on his press for listing of the matter after on 3rd. Although Mr. K. Lawyer learned CGC for the applicant objected to such prayer on the ground that matter is pending. The delay condonation is pending since more than 1 year, considering that the learned counsel, Mr. Picha, to the respondent is under medical treatment, that this matter be listed on 3rd.
Much
Deeply obliged.
Item number 1.
May it pleases your Lord.
Yes.
This is an appeal. Another writ appeal against the judgment and order dated 14/8/2024 passed by the learned single judge partly allowing the writ petition number 56 of 2022. Under the facts of the case is that in person to the NIT for the transportation of food grains from RS Bhalapung to Bomdila, the petitioner respondent has bidded for the tender, my lord, and she came out L1, my lord. Her quoted rate was 1,100 per MT for the entire distance, my lord. So accordingly, a letter of acceptance was issued on 23/8/2021, asking her to submit the security deposit and bank guarantee. But on 10/9/2021, the petitioner requested to cancel a letter of administration due to some unavoidable circumstances, maybe the the financial issues, my lord. So what happened that as per the MTF, the FCI has terminated the contract on 5/10/2021 with risk and cost against the petitioner and also debarring. So that was challenged before this honorable court, before the learned single judge. And the learned single judge was pleased to partly allow the writ petition. And it was held that the letter of acceptance ought not to have been issued, my lord. So on that ground, my lord, we have filed this writ appeal.
Letter of acceptance?
Letter of acceptance, my lord. Letter of acceptance ought not to have been issued, my lord. That was the learned single judge has held that the letter of acceptance ought not to have been.
Under what provision you have passed this order?
My lord, I will take your lordship straightway to the termination order dated 5/10/2021 at page 107.
Can it be disposed of today?
Well, it will take time. My matter may be admitted and may be taken up for hearing, my lord. If my learned friend.
107. Yes. Let us see what is this.
Yes, my lord.
Under which clause you have?
My lord, by the letter of acceptance, security deposit and bank guarantee was to be submitted, my lord, by the petitioner. But the petitioner has issued a letter dated 10/9. Now, as per the MTF, my lord, your lordship may kindly come to page 108, paragraph 5. May I read it? Thus, it is clearly established that Messrs. Argi Enterprises has failed to submit the required security deposit amounting to rupees 7,60,000 and withdrawn his officer in the said tender, which is in violation of the provision of MTF clause 8G, which speaks, it should be clearly understood by the tenderer that no opportunity shall be given to them to alter, modify or withdraw any offer at any stage after submission of the tender, and invites appropriate action as per the MTF clause 9E. The bidder has not only failed to comply the provision of MTF, but also has wasted valuable time and resources of the corporation. Thus, keeping in view the facts that the circumstances of the case as detailed above, the bidder, Messrs. Argi Enterprise, is liable for debarment from participating any future tenders of the corporation for a period of 3 years from the date of issuance of this tender. 6. Therefore, in exercise of the power conferred under clause 9E, which speaks in the event of the tenderer failure after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7(1)(a) by the due date, or requisite security deposit in the form of bank guarantee under 7(1)(b) and 7(1)(c), including extension period, his contract shall summarily be terminated besides forfeiture of earnest money, and corporation shall proceed for the appointment of another contractor. Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and the law. The contract will also be debarred from participating in any future tenders of the corporation for a period of 3 years. After the completion of the prescribed period of 3 years, the party may be allowed to participate in future tender of FCI provided all the recoveries dues have been affected by the corporation and there is no dispute pending with the contract party. The road transport contract XRH FSD Bhalukpung to FSD Bomdila accepted by this office by letter of acceptance cited and reference to is hereby summarily terminated with immediate effect and the corporation shall proceed for the appointment of another contractor at the risk and cost of the terminated contractor. Any losses of damages, if any, arising out of the same and incurred by the corporation due to conduct of your firm would be recovered from Messrs. Erge Enterprises without prejudice to any other rights and remedies available to the corporation under the contract and the law of the land. The tender is also debarred from the participating in any future tender for the corporation for a period of 3 years under MTF clause 11E, 9E. My lord, may kindly also peruse the letter of the petitioner dated 10/1/2021, my lord. That is at page 106, my lord. Page 106, dated 10/9/2021. May I read it, my lord? Sir, with reference to the above subject, I have the honor to state that due to unavoidable circumstances, I could not make security deposit and bank guarantee amount to FCI Itanagar.
What is
There-
clause 9? Clause 9?
Clause 9, my lord.
Clause 9. Where is clause 9?
Yes, my lord, I'm coming to it, my lord.
Page 81, madam. Page 81.
80.
Page 81, my lord. Page 82 is the E, my lord.
Nine E.
E, my lord, at page 82.
In the event of
In the event of the tenderer failure, after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7(1)(a) by the due date or requisite security in the form of bank guarantee under 7(1)(b) and 7(1)(c), including the extension period, his contract shall summarily terminated beside forfeiture of earnest money, and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of the incurred by the corporation by such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and the law. The contractor will also be debarred from participating in any future tenders of the corporation for a period of 3 years. After the completion of the prescribed period of 3 years, the party may be allowed to participate in future tenders of the FCI provided all the recoveries due have been affected by the corporation and there is no dispute pending with the contractor party.
So under this clause 9E, you have
Yes, my lord.
terminated the contract.
Yes, my lord. Because the tenderer has failed to deposit the security deposit instead by her letter dated.
The question of risk and cost.
Question of risk and cost is there, my lord.
Hmm?
My lord, your lordship will find the risk and cost under clause 7(1)(a), 1(b), and 1(c), my lord. No, it is there, it's 7(e). Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will recover from the contractor. This is the risk and cost, my lord. My lord, the petitioner has submitted a letter dated 10/1/2021 at page 106. By that letter, she has requested that due to the unavoidable circumstances, I could not make security deposit and bank guarantee amount to the FCI Itanagar. Therefore, I request to cancel the letter of acceptance. Now, while preferring this writ petition, she has taken a technical ground that letters of acceptance ought not to have been issued because the signed MTF agreement was not submitted. And therefore, the letter of acceptance ought not. So this stand the petitioner has taken for the first time in the writ petition only. Whereas if your lordship will see her letter at page 106, she is saying that due to unavoidable circumstances, I could not make security deposit and bank guarantee amount to the FCI. Therefore, request to cancel the letter of acceptance. She herself has said that the letter of acceptance. Yes,
not
my
the
lord.
contract.
Letter of
There's
acceptance.
no signed contract. Contract was not signed.
Contract was, my lord, at page 78, your lordship will
means
see there is a signed document, signed contract. She has to upload in the e-procurement
That
at the
has
time of.
That has not been done.
She has done, but only thing is that she later on, after the acceptance of letter of acceptance, your lordship may kindly see where she has been directed to submit the letter of acceptance also. I mean the signed tender agreement also.
That's been done or what?
That was not done, my lord.
If that is not done, contract is not concluded.
No, my lord. My humble submission is that, my lord, the contract has been concluded by the issuance of the letter of acceptance, my lord.
No. Letter of acceptance you can issue. It's up to them until thereafter only when the tenderer accept it and sign the contract, then it's become complete.
Well, on this point, I would like to rely on our honorable High Court judgment that reported in 2022 5 GLT 820, my lord, page 820.
Saying what?
Saying that the issuance of letter of acceptance is, my lord, that contract has been concluded, my lord.
How?
If I can.
So there's no requirement of signing a contract.
There was a requirement that was in that case, my lord, the letter of agreement was to be submitted later on, my lord. But letter of acceptance was issued. Security deposit was.
Obviously, the letter of acceptance was issued. She could not furnish all these things. Therefore,
no, my lord, she has already found. If your lordship will kindly see the other clauses, my lord, I would like to rely on the other clauses.
What are the other clauses?
Page 77, my lord. From page 77. Relevant clauses, my lord.
That has been clause E.
Clause is the termination. Clause is the termination clause, my lord. At page 77, earnest money. I would like to rely on clause 6, 7, and 8. At page 77, my lord. May I read the clause 6, my lord? Page 77. Page 77, my lord. Clause 6, earnest money. Each tenderer must be accompanied by an earnest money of rupees 3,04,000, which must be submitted electronically through NEFT, RTGS, other electronic means by the tenderers, for which the concerned FCI RO will provide its bank account number and concerned branch of the bank so and so. This is important, my lord. The tenderer shall be permitted to bid on the express condition that in case he resile or modifies his offer or terms and conditions thereof after submitting his tender for any reason whatsoever during the tender process, the earnest money deposited by him shall stand forfeited without prejudice to any other rights and remedies of the corporation under the contract and law, and the tenderer will be liable for any losses suffered by the corporation on account of the withdrawal, modification, etc. Beside forfeiture of EMD. He will be debarred from the participating in any other tender inquiry with the FCI for a period of 3 years. So 6 also says that if he or she resides from his offer, my lord. Then clause 7, security deposit. Security deposit has to be done, my lord, within 15 days, working days of the acceptance of his tender. A security deposit for due performance of his obligation under the contract. The security deposit shall consist of so and so. Now, 2 is important, subclause 2, 7.2, my lord. In case of failure of the tenderer to deposit the bank guarantee as stipulated in 7.1b and c within 15 working days of acceptance of his tender, further extension of 15 working days can be given subject to levy of penalty at 1% of the whole amount and the security deposit, and another working days of, this is the extended clause, Your Honor, Your Lordship. Now 4, subclause 4. In the event of tenderer's failure after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7.1a by due date or requisite security deposit in the form of bank guarantee under 7.1b and 7.1c, including extension period, his contract shall be summarily terminated beside forfeiture of earnest money, and corporation shall proceed for appointment of another contractor. Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and the law. The contract will also be debarred from participating. So, my lord, this 7.4 is important. In case after the letter of acceptance is issued and he or she fails to furnish the security deposit, the tender will be terminated, my lord. 7.4 also, my lord. I am heavily relying on 7.4, my lord.
But 7.4 has not been.
Now the learned single judge has taken recourse to clause 8e, my lord.
No, that you
in
have.
partly allowing the writ petition, my lord.
7.4 was not placed. It was not argued before the learned single judge.
It was all the points was raised, my lord. But while all the point was raised, my lord.
How do we know if it is not recorded?
That is the reason, my lord. That is not recorded, my lord, but all the point was raised, my lord.
7.4 was 7.4 was not raised.
No, my lord, raised. It was raised, my lord. So at this juncture, my lord, I pray that the matter may be admitted.
Clause 8.
8e, my lord.
8e and 9 only.
Now, while allowing the writ petition, the learned single judge has taken recourse to 8e, my lord.
That you have
but ignore the 7.4, my lord. That is my case, my lord.
7.4 you have not.
Now I have raised, my lord. That is my case, my lord. Therefore, because of that, I am before your lordship, my lord.
How do we know? How do we know that you have raised this? It's not recorded.
Not recorded, but I have argued the point, my lord, as per from the tender document, my lord.
You have filed an affidavit in that sense. You have urged the point, but it was not considered.
Let me file the additional affidavit, my lord.
Is not it?
Yes. Let me file my lord. May I
Yes,
pray
sir.
for filing of the additional affidavit?
As per clause 7.
My lord, but my lord, my case rests on my lord, clause 8 of the my lord, the tender, my lord.
Huh.
Clause 8 it says, my lord, acceptance has to be, my lord, preceded by, my lord, the fulfillment of, my lord.
But understood. But clause 7.4, it says if you have failed to, if you have not deposited the BG,
Yeah.
bank guarantee and other security deposit, after the communication of the acceptance
Yes. My lord, yes,
letter.
my lord, that will come only after the my lord, fulfillment of, my lord, clause 8E, my lord.
Hmm.
Clause 8 it says, my lord,
Huh.
before acceptance of the, my lord, issuance of the acceptance, my lord, the clause 8 has to be, my lord, complied with, my lord.
Hmm.
Clause 8 says that, my lord, I have to submit, my lord, if I am a successful reader, my lord, that will be intimated to me. Then I will be submitting, my lord, the hard copy, my lord,
Hmm.
the signing of the hard copy. Then only the acceptance will be issued to me, my lord.
Hmm.
Only here in the case, my lord, kindly, my lord, see, my lord, clause 8E, my lord, for a moment, my lord,
Hmm.
page 78, my lord. May I read, my lord?
Yes.
Tenders should be uploaded, submitted through e-procurement at a given website. Manual bids, hard copies of the tender document will not be accepted. However, the successful tenderers will have to submit the original hard copy of the MTF
What is
duly.
MTF?
My lord, is the
Model tender form.
model tender
That
form.
that is the agreement, my lord.
Okay.
And duly signed on each page of the MTF along with annexures, appendices duly attested on or before the date and time stipulated by FCI, failing which the EMD furnished by the bidder is liable to be forfeited. In my case, my lord, I have not submitted any EMD because, my lord, I am a, my lord, MSME registered firm, my lord. And it's been, my lord, excluded, my lord. There is a relaxation, my lord. And further, that the award of the contract, my lord, through the letter of acceptance, will be issued to the successful content tenderer only after he fulfills this requirement. My lord. My lord, kindly see, my lord, the acceptance letter was issued on, my lord, 23/8/2021, page 101, my lord.
Hmm. This is a little, reverse the normal course, kind of
Yes.
cases.
Yes, yes. My lord.
Normally, the petitioner and the tenderer approach the court for award of the contract.
Yes, my lord. My lord,
This other,
Yes.
other way around.
Yes, my
You have been given
Yes.
and you don't want.
Yes, my lord, this entire event happened during the COVID period, my lord.
Hmm.
That's why, my lord, I have some financial difficulties at that time, my lord. My lord, the acceptance letter was issued on 23/8/2001.
Hmm.
This
I
was
I think we'll admit it, list for hearing.
my lord, but no stay, my lord, because,
Huh?
my lord, no stay,
No,
my
we'll
lord.
not say anything now.
My lord.
All right.
Yes.
Let's be better.
Yes.
Heard Mr.
BK Singh, my lord.
BK Singh, learned counsel for the appellant, and also heard Mr. Arsakia, learned senior counsel assisted by Mr. M. Tasa, learned counsel for the respondent.
Yes, my lord.
Respondent, public writ petitioner. Next, admit list for hearing after 3 weeks. After 3 weeks.
My lord.
Meanwhile, my lord, I will file my one additional
It's up to you because
my lord.
as per the judgment, it doesn't indicate that
Yes,
you
yes,
have
my lord. I will.
say clause 7. Only 8 and 9 has been discussed
Yes, my lord.
and considered.
8 has been interpreted, my lord.
Yes.
Oblige, my lord.
Item number 2.
Wait, please, Lordship. Please.
Paper book is prepared.
Jail admitted, list for hearing.
Admitted. It has been
Jail appeal, it may be admitted. Lordship.
already admitted.
Paperwork received.
Huh?
Paperwork received.
Yes, sir.
Paperwork received, madam.
It's not admitted as yet.
No.
Admitted.
All are represented.
Yes,
Yes,
madam.
Lord.
Not yet admitted.
Only
Not
not
yet.
admitted. Heard Mr. Ubari, learned counsel for the
Alice Lordship.
Alice, learned legal aid counsel for the appellant. And also heard Mr.
Already admitted.
Admitted. Sorry, it is.
23 for. 23 for.
Okay. Okay, it's already admitted. 23-4.
Yes, my lord. It's admitted for hearing, my lord, on 23/4/26, my lord.
So then you write same you learned legal aid counsel for the appellant and Mr. Theatre learned additional PP for the state as well as Mr. S. learned counsel for
Victim.
you are also legal aid counsel. Legal aid counsel. Huh?
Private.
Okay, counsel for respondent number 2.
Yes.
Paper book is prepared and same has been served to the parties as agreed to by parties. Let this matter be listed for hearing after 3 weeks.
Yes, ma'am. Obliged, ma'am.
Hello.
Item number 3.
Lordship, before my learned friend is
No affidavit.
Yes, Lordship, I need some more time because
Heard Mr.
P. Obin, my lord.
P. Obin learned counsel for the petitioner
next,
as spread for by Mr. M.S. G. learned additional senior government advocate. But the 2 weeks time is 3 weeks time is granted to file affidavit in opposition.
got it. Fix that.
List accordingly.
Fix it. My lord, may I pray for a fixed date, my lord? It's the
After 3 weeks.
22nd.
Huh?
22nd, my lord, is
22nd.
September 22nd. my lord.
9. 22nd 9.
My lord, how much of it?
Obliged.
Item number 4.
Yes, what's happening?
Your Honor, sorry.
This is of what? This is for what?
Lordship, I've received the reply from the state government.
Yes.
They have annexed a judgment from the Supreme Court, an order for the renewal of the land allotment. And on view of the record, Your Honor may give me time to reply this.
Mr. Omodi. Titatak. Titatak, land counsel of the writ appellant. Press for and is granted 3 weeks time to file affidavit in reply.
Deeply obliged.
Mr. Anderton, London Additional Advocate General and MS. NRU, London Counsel for Respondent 2 and 6 are present. August.
Item number 5.
May I please, lords?
My lord, on last occasion, my lord, instruction was sought for, my lord, from the respondent.
Lordship, I have not yet received the instruction. So I may be given another 1 week time, Lordship.
One-man commission
Lordship.
Inquiry report.
was constituted.
Inquiry.
Yes, ma'am.
Huh?
Yes, ma'am.
Last order. Whether it was constituted under the Provisional Commission Inquiry Act or what?
That has to be seek, ma'am.
That query I have made to the authority. Lordship.
Okay, heard Mr. H. Lampu, counsel for the applicant oblique writ appellant.
Petitioner.
Writ petition, huh? Writ petition. As spread for by Mr. S. Learned counsel for the Learned senior government advocate. Let this matter be listed after 4 weeks. 3 weeks.
Yes.
So as to enable him to obtain instruction
Hmm.
as allowed by this court, as directed by this court on 13/08/2026.
My lord, can
Okay.
it be
According-
after 1 week, my lord?
1 week,
2 weeks, Lordship.
2 weeks. Make it 2 weeks.
All right.
Item number 6 and 7.
Can be without the live streaming?
Live stream of.
Yes.
I have objection, my lord.
As who prays for and is granted 3 weeks time to file affidavit in reply.
And my lord,
Mr. N. Ratan, London Additional Advocate General for the State, Mr. T. Tatak for
the implemented.
newly implemented respondents, my lord.
respondent number, private respondent.
Private respondents, my lord.
Huh?
All the private respondents.
Oh, private respondent. Ojerang. DSJ, on behalf of DSJ, as well as MS. Then we said MS NRG for response 7 and Mr. MS Ojerang for DSJ, appearing with DSJ, and Mr. T. Tarak. You're the last man
Last one.
in the area of party. Otherwise, you are always in front.
My lord,
Are present. Thank you. After 3 weeks.
my lord, in the meantime, my lord, there's little pressing matter. So I'm seeking for some kind of interim protections or say interim
Not
orders
today,
from my
not
lord.
today. You file the affidavit, will complete the matter. But this is also something.
Yes.
See, nobody is denying.
Of
The process has to be done.
that's precisely
There is a
yes.
gray area where it says that 16 tribes, right?
Yes,
26 tribes.
26.
All these tribes, including
16. Yes.
Include. Yes.
no, the tribes, including these tribes.
Yes, ma'am.
What is the language in the
All
Constitution?
tribes, including. That's
All
that's
tribes of
So there's a gray area. It has not been settled.
Yes.
Therefore, it's better to go for, instead of litigating, go for get it the process done. Get it.
Yes.
my lords, my lords,
Let the Parliament pass the
yes.
law. An amendment can be made in the constitutional or the presidential.
That's exactly, my
There's
lord.
a way out. Nothing else.
My lord, there is a
Nobody is. Forget about what?
No, my lord. May I just take a minute, my lord?
Huh.
Now, I bow down to what my lords are saying, that yes, the parliament amendment has to come. Now, the parliament amendment has to come for what reason? It's just to include the name of the Yobin by specific. That's the only thing.
It's a law requires that it has to be by the parliament.
No,
you
but
read the case of Milin.
Milin Suman, my lord, there are
Not
Milin
Milin
Suman. Milin Suman, it is there, my lord. There is also
Not
other
Milin
cases. There is also other cases, my lord. Why we are before my lord, and this is not an adverse.
That we have
litigation.
understood the
Yes.
way it has
Yes.
to be done. What law prescribes.
Exactly, my lord. It is. So, my lord, what we are before my lord, and why I am before my lord is also actually, my lord. I am not before my lord
See,
seeking.
admittedly, there's no, amendment to the presidential order where your name is not shown. So that's why I'm saying there's a gray area when it says includes.
Yes,
When not, nobody's.
my lord.
State is not denying that you are not an
that is the
ST, scheduled
catch.
tribe of Arunachal.
That is a
It's a
catch.
formalities to be done.
No, but when will
prescribed by the
my
law.
lord? They cannot take
And
70
it's
years to.
only even the state. Want you also, state cannot.
Of
They
course,
don't have
my
the
lord.
power. It's the parliament.
It is.
That's
It
why
is.
I said read Millen.
My lord, I've read the Milan. My lord, there are other.
The state nor
that's
the
a-
court has the power to amend that presidential order.
My lord,
Only the parliament.
my lord
So
has.
it's well settled. Thank you.
My lord
We'll
has
hear you
missed
after 3 weeks.
3 weeks, my lord. 22nd,
Yes,
my lord.
your affidavit.
22nd, my lord. 22nd. 22nd, my lord.
22nd.
Yes, my lord.
We are just trying to suggest you the way out.
No, my lord, because I bow down to what my lords are saying. But what I am before my lord,
If you bow down, nothing more.
what my
There's no
points are there.
Ifs and buts.
My lord.
Thank you.
Well, much obliged.
Item number 11.
My lord.
Yes.
My lord, as per last order, my lord, I had to file condonation application as well as memorandum of appeal. But my lord, I have not received TCR, my lord.
Huh?
I have not received TCR, my lord.
TCR is there. We'll direct you to provide. Yes, heard, Mr. No, the registry to record. Trial court record is received. Registry to furnish the relevant materials to learned LAC, Learned Legal Aid Council, Mr. Nossi. L. Nossi. Huh? So as to enable, please stop. The learned and for filing filing
Condonation application.
condonation application
As well
as appeal memo.
Yes, my lord. After election.
List the matter after. We'll make it 2 weeks. 2 weeks you file, we'll consider.
Of like.
Yes.
Item number 13.
Please, my lord, I think there was a miscommunication, my lord. I was supposed to take steps, my lord. The steps was taken, but then it has not been reflected, my lord.
When did you take the steps?
On the same day, my lord, on 27th, my lord. So may I humbly pray as of now, my lord, I may be allowed to take fresh steps, my lord.
On the prayer of Mr. Opada and counsel for the appellant, a week's time is granted to take fresh steps.
My lord.
MSL learned additional PP is present. List after 4 weeks. 4 weeks.
May I please, my lord, since it is a criminal appeal, my lord, and I'm praying for suspension of the, the
Not like that.
order of conviction, my lord. May I humbly pray, my lord, if
You
you can.
file first.
It's a criminal appeal, my lord.
Take steps. We'll consider. Your IA is there.
Yes, my lord. I'm
Not
for the IA, my lord. Therefore, my lord. Not today, my lord. Therefore, my lord, if I can have a fixed date, my lord.
After and then back it's 3 weeks.
September, 15th of September, my lord.
15 September.
My lord. Obliged, my lord.
Alright. Item number 14.
On the last occasion, I have applied this code that the complainant has shifted to another address. Your Honor.
Address.
Therefore, the service could not be completed here. Therefore, I filed one additional affidavit. Okay.
So
Lordship, I may be allowed to amend the post title of the appeal. And in the meantime, I may be allowed to take fresh steps.
so this should not be additional effort. This should have been IA.
For correction of.
We'll say, and then we'll say they will say the affidavit will simply say.
But then I think are they allowed? Are they allowed? I think.
For IA, this thing, additional. Registry has verified an additional affidavit.
Additional affidavit for correction. On his prayer. Can be allowed. Thank you. Correct. I mean.
They heard Mr.
Okay, Paramachu.
Heard Mr. So and so. The appellant has filed. You have filed as a lawyer or the appellant?
Lordship, father of the appellant.
The father of the appellant has filed an additional affidavit bringing on record the new place of posting of the complainant of the respondent for please stop, Next paragraph. It is a perusal of the same indicates that the respondent, this is a respondent number 2.
Yes, Lordship.
Respondent number 2 has shifted,
Transferred, Lordship.
It has been transferred from its transfer from earlier place and shifted to new place of posting. Where? At?
Alo, Lordship. Care of District Medical Officer, Alo.
At Alo, under the establishment of District Medical Officer,
Yes,
West Alo. List of for service of no Mr. In view of above, the petitioner is allowed to file amended cause title in the criminal appeal in respect of the respondent number 2. Next para. The yes, we have allowed you file it.
Lord, I will also allowed to take fresh text, Lord.
The
In the meantime.
Land Council for petitioner to file amended cause title. List of next para. Registry to incorporate the respondent number 2 with this with her
Yes, Lord.
with her new address. List of thereafter petitioner and the council for the petition appellant to thereafter steps be taken.
Yes, my lord.
Just pending one IA also.
There also, my lord, correction is required, my lord. IA for suspension of sentence, my lord. There also same order may be passed, my lord.
Same order in IA.
Obliged.
After
3 weeks.
and
You record his name. The learned for the state is present.
Obliged.
Item number 15.
Yes.
My lords, there is a delay of 42 days and the respondents wanted to file an objection. So till now, they have not filed an objection.
Who is the respondent?
Uh,
Private respondent or state?
no, that's as a state respondents, my lord.
State?
State respondents, my lord.
You want to file?
No, your lordship, I'm not going to file.
Who said?
There is an order, my lord.
On the premise written learned council for the service of notice of people. You have taken steps or what?
I have taken the steps, my lord. Kindly look at 21st of July, my lord. On the prayers, the council pray for that.
Petitioner to break step 3 weeks.
Steps we have taken, my lord. Earlier, there was some error in the address of respondent number 5. So thereafter, we did the corrections and we have taken the steps. P. Yobin, my lord.
P. Yobin, learned counsel for the applicant. Next para. And also her MS P. Pango.
For 1, 2, and 3, your lordship.
And state counsel for state respondents. And MS.
Appearing on behalf of M. Kapoor. Respondent.
Your name, please.
LKG.
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 Kechi.
KJ.
Keche. Learned counsel appearing on learned DSGI. Next para. Office note dated 24/8/2026. Reflects that the current respondent number 5 has been received back after service of notice. Just accordingly, the service in respect of respondent 5 is complete. Next para. This application under section 5 of India Limitation Act 1963. This is an application under section 5 of Indian Limitation Act 1963, seeking condonation of 42 days in filing the connected writ appeal against the judgment and order dated 10/11/2025 passed in WPC 148 of 2023. Where is the ground?
My lord, paragraph 3, I've tried to explain there, my lord. That Because there are group of people, my lord. So it took some time for them to seek legal assistance. And paragraph 4 also, my lord, sir. 5.
Simply say, where is the grounds oblique explanation for delay in filing the connected writ appeal as explained. Now, as put forth at paragraphs 3, 4, 5, and 6, list of perusal of the same reflects that there is no what I said, the perusal of the same reflects that the applicant could show sufficient cause in preparing the in not preparing the connected writ appeal within a limitation period of time, within a limitation period. List of having considered above and the prayer not being objected to by learned counsel for the respondents, who are satisfied that sufficient cause has been shown. Accordingly, the delay of 42 days in preferring the connected writ appeal is conducted. IA stands as allowed and disposed of. Yes, 16.
Item number 16.
My lord, much obliged.
Obliged, sir.
Yes.
My lord, is step taken in favor of R4, private respondent, and notice issued, but
IA is for what?
IA is for condonation.
How
For
many
6
days?
Your lordship, it is a delay of 6 days, my lord.
6 days.
My lord,
On private respondent is there, my lord.
Notice has been issued.
notice has been issued, my lord.
Who is private respondent? Will he be affected?
Yes, he will be affected, my lord, because his appointment is under challenge, my lord.
Sitting Naksal.
My
Okay. So we'll wait for some time. Yes.
I
wait. When the steps were taken? 1906. The third time. Today will be third time.
Okay.
On 1906, 7, 8.
Not
2 months.
Fresh step.
Can you take press steps?
My lord, yes, my lord, I can
You take press steps. It's been 2 months.
Yeah, my lord. My lord, I have
More than
taken
2 months.
steps.
Right? No, nearly 2 months. 19.
As per Indian Postal Report, he has received the notice. As per Indian Postal Report, he has received the notice.
Who has said?
R4.
There's nothing. When the report says something else.
My lord, second page and first page, that is receiver, and it is delivered. It has been received by the R4 on 23rd of June, but not present.
Although Mr.
A.D. Verma on behalf of T. Taba.
A.D. Parma, Learned Counsel, appearing on behalf of Mr. T. Tabak, Learned Counsel, by placing the tracking report, a postal tracking report submitted the service of notice upon respondent is shown to have been delivered.
My lord, if I may say one word.
The office note dated 24/8/2026 reflects otherwise, as it is reflected that ID card in respect of respondent number 4.
My lord, there is a RTI I have submitted.
It's okay. In view of raised it to verify, unless the matter on 27, day after tomorrow. We'll see day after tomorrow. If it's delivered, we may allow it.
My lord.
We'll come back after something. Okay, wrong. We'll resume after some.
Item number 17.
There, please. 17.
Yeah, Worship.
Hearing.
Yes.
Yes.
This is a read appeal, my lord. It's directed against the, my lord, impugned judgment and order dated 7/3, passed by the learned single judge in petition number 215 of 2021, my lord, whereby the writ petition 215 was dismissed. My lord, basically, may I check to the, my lord, this impugned judgment, page number 27, my lord. 27 it starts, my lord. Then page number 29, my lord. I am basically agreed by this observation made in para 7 of the impugned judgment, my lord. Therefore, I will just read out this portion, my lord. Therefore, whether the petitioner would be entitled to possess the land measuring 50,000 square meter, while the LPC itself has come under cloud. Even if the petitioner is found to be entitled to the possession of 50,000 square meter in terms of LPC dated so and so, no construction of approach road as proposed by the petitioner can be permitted to be done, as the same would pass through a wildlife sanctuary and forest area within the meaning of the Wildlife Protection Act 1972 as well as Forest Conservation Act 1980 respectively, as is found from the impugned letter dated so and so issued by the Chief State Officer, Government so and so and so. My lord, this particular observation, my lord, the first portion is saying, my lord, basically, my lord, this 50,000 area square meter, my lord, LPC was issued in my favor. Then, my lord, my lord, there is a government notification whenever you want to do some construction or earth cutting, even though you may be having LPC, by way of notification, you need to obtain a permission. So, in consonance of that notification, I applied to the Chief State Officer. Chief State Officer initially declined, my lord. I approached this Honorable Court. This Honorable Court categorically directed to the Chief State Officer that you cannot ask the petitioner go and get the NOC from the Forest Department, because within the parameters of notification, that your duty is just to see that those required documents and the relevant factors, you have to confine to that one only. You cannot ask petitioner, you go to that department. That part has been, my lord, decided by the learned single judge in the first writ petition. Thereafter, I submitted. Now, when I applied for the application, it is something, my lord, I wanted to construct the road within this LPC area, Your Honor. It is not something beyond LPC area. Now, very interesting, my lord, these findings of the, with due respect, my lord, with due regard, this finding of the learned single judge, my lord, that first is saying that even his 50,000 LPC area is given to him, which is under cloud. Now, if construction takes place, it will be something, it will pass through the wildlife sanctuary and forest. My lord, this part this finding.
Let us see the order, letter dated, impugn order.
6/4/2021, my lord.
Yes, where it is.
My lord will find at page number 84, my lord.
84.
My lord. A type copy is 84, my lord. This was, my lord, pursuant to the direction of this honorable court. I submitted fresh application. Thereafter, this impugn order was passed, my lord. May I read, my lord? Agreed by my direction to obtain NOC from the Department of Wildlife Warden and PW Division. You have preferred a repetition before the Honorable Gauhati High Court, Itanagar Permanent Bench, by so and so, and the Honorable High Court is pleased to direct the undersigned wide order dated to issue NOC on fulfilling all the requisite as stipulated in the notification and accordance with law. The Honorable High Court has further directed the undersigned at liberty to make verification before issuing NOC, if necessary, by consulting the concerned departments, wildlife warden and PWD. Consequent upon the directives of the Honorable High Court to make necessary verification before issuing NOC, the undersigned has passed over an order dated so and so for necessary physical verification of LPC plot before issuing NOC, which was duly served to you. Meanwhile, a copy of representation addressed to Deputy Commissioner under the subject cancellation of LPC white letter is submitted by the Deputy Chief Wildlife Warden Itanagar, seeking cancellation of your LPC number dated so and so, stating that no NOC was obtained from Itanagar Wildlife Sanctuary Authority, which is highly objectionable and clear violation of Wildlife Protection Act and so. On the stated ground of objection from the Itanagar Wildlife Authorities, your application for NOC for earth cutting and so is hereby denied. Now, the reason given is that some purported objection was filed before the Deputy Commissioner by the Wildlife or by the Forest Department, saying that raising certain objection against my LPC. Now, my lord, we have to take into some historical account, my lord, in this particular case, my lord.
No, will not.
My lord,
since it's admittedly it says that they filed already the complaint, objection.
My lord.
A representation addressed to the submitted by Deputy Chief Wildlife Warden.
That's why.
For cancellation.
That's why, my lord. Now, my lord, this cancellation, my lord, first, my lord, I will just submit, my lord. This is what happened in 2004, my lord. In 2004, it starts from 2004 when I was trying to develop my plot of land in 2004. Eviction notice was issued by the Wildlife Sanctuary Department. That eviction notice was put to challenge before this honorable court. This honorable court quashed that eviction notice, directed the Deputy Commissioner to consider the claim of the Forest Department as well as the petitioner to find out whether this land falls under the forest land or not. Then Deputy Commissioner, my lord, in the year 2005, passes the judgment saying, my lord, that Forest Department failed to show that the land in question falls under the Forest Department. This is the matter of 2005, my lord. Now, since all these years, for last 20 years, no issue, my lord. Since 2004, I've been in, my lord.
No, what about this representation, the objection filed by the Wildlife Warden?
My lord, as on today, even I have not received that objection letter also, my lord. And nothing, my lord. Now, my lord, my lord, now issue is like this, my lord, here in this case, my lord. Basically, why I'm agreed, my lord. This observation that any construction that which I am seeking, my lord, that will fall within the Forest Department. This conclusion, my lord, there is no materials to come to that conclusion.
No, it's there. This as per this page 84, 0060.
This is at the most. See,
your LPC has been obtained. It said under a subject consider LPC is submitted when returned, stating no NOC was obtained from the Eternal Wildlife Sanctuary, which is highly objectionable, clear violation and so on.
May I clear? Now, when he is denying this order, he is acting as a Chief Estate Officer. Chief Estate Officer under Arunachal Pradesh Eviction of Unauthorized Open Act. He is not a Deputy Commissioner. State officer doesn't have any authority to decide about whether the LPC rightly issued, wrongly issued. He has no business.
It's when there's a complaint, objection, that has to be decided first.
That's my lord. That's why I'm saying, my lord. Now this has become a disputed question of fact. Now today, my lord, I am also not saying that I need the permission to get the construction or for cutting or cutting. I also want, because once 2004, it was 2005 already decided. Now it seems Forest Department, they have again filed some complaint against me before the deputy commissioner. Until that, I have not received any notice, nothing I know. I also want that this repeated objection, I also want get clarification.
Go there, we'll give you a liberty.
Now, only my prayer, my lord, at this stage. This observation that it falls without, my lord, this is a heavily disputed question of fact, because I am disputing this is
So
false.
in any case, when the writ petition, you have challenged this denial of NOC.
Yes.
Denial of NOC, you have agreed your writ petition is filed.
Yes.
And on the basis of this denial record, the Learned Single Judge has said you cannot be given an NOC.
Now, that's why, my lord,
That's all.
this observation that the lane where I propose to construct road, for which I am seeking this permission, my lord. How that, my lord, with due respect, Learned Single Judge come to the conclusion that this land belongs to the forest. Then entirely matter, my lord, this is the end of the chapter.
No, it says.
Now, my
It says whether the petitioner would entirely possess the land so and so itself has come under cloud only.
No, let
this cloud you get yourself clarified from the appropriate authority.
Yes, my lord, my lord. I will do it. This part portion, my lord. This paragraph 7, my lord, then my lord, the below
even
part.
if the petitioner is found to be entitled to possession of private land in terms of LPs, no construction or approved road so and so can be permitted.
Yes, my lord.
As the same would pass through the land.
Yes, my lord. My lord, this conclusion on what basis, my lord?
It says it's that thing, denial of NOC.
My lord, denial that.
Why cancellation? Why cancellation? Why they have sought for cancellation of LPC by the wildlife warden? Because it's
No, that
no
matter
objection.
that matter has to be adjudicated.
Go there, not here.
I am ready to go there. But what will happen about this observation by the Learned
Just
Single
make
Judge?
an observation that
these
you have
findings should not.
liberty to approach the appropriate authority to get the this thing NOC cleared.
Yes, my lord, get a KNOC or whatever, maybe they may initiate the process.
Whatever.
I have a remedy. I can go to the civil court. Anything I can.
You go there.
I am now what the problem, my lord. This conclusion, without any basis.
No, we'll say, why not interfere with this? We don't find any. However, we'll just clarify that any decision as regards the LPC of LPC in your favor, any decision shall not be influenced by the order of this Learned Single Judge. Simply we can say
that is there, but my lord, my basic grievance is this conclusion. Coming to this observation, there is no basis, my lord.
They say there's a complaint.
Complaint is something, my lord, the complaint, it can be language big. There is a complaint, allegation is here.
We'll clarify to the extent that any decision, cancellation or accepting the NOC shall not be influenced by the order of the observation made in the orders. We'll just say,
and
that's all.
And that right over that lane kept open, my lord. This is what I am having the problem in this.
Okay, heard, Mister. That's
Lordship,
all.
Lordship.
My lord, otherwise, my lord.
Just 5 minutes, Lordship. Because Lordship, in the wildlife or forest, they have not met party in the writ petition, Lordship. And then in the appeal also, they did not meet as a party. But then the Honorable Court have directed them to, we have been implemented that way, Lordship. Well, I have filed my affidavit. They haven't said anything. We have shown that this place, the petitioner's place falls under the reserve forest, Lordship.
We'll record that. You have not been allowed to file affidavit in the writ petition.
Writ petition, I was not a party. Only the
in the appellate
deputy commissioner, estate officer only, and he had an standing counsel. That's why it's shown his absence also, Lordship.
Because he was agreed by the order of the
state officer.
Only that,
May I clarify one thing?
My if para 10 also, he haven't, Lordship, filed rejoinder against all of this. We have clarified everything.
Where you have filed?
Lordship. By
This
the,
proceedings or before the learned single judge?
no.
In a writ appeal?
Proceeding, Lordship, because we are the new party here.
Okay.
May I
As per the
clarify?
Honorable
So
Court,
we're not allowing the appeal, we're dismissing the appeal
yes,
with just an observation. Because your basis is that there's a representation for cancellation. Whether this has been cancelled or not, that has to be settled.
And
Isn't it?
Lordship,
A representation was filed by the wildlife warden
yes,
for cancellation is LPC.
yes.
You verify,
In
work
the
it, take a decision, take a call.
why
If
the-
it falls, you cancel it. Wrongly or rightly.
Sanctuary, Lordship, Deputy Commissioner have no authority to issue LPC, Lordship.
That's why you have to cancel. If you don't have an authority, cancel it. But for that, you have to take a call. Decision has to be taken.
Lordship, we have said so, Lordship, that's why.
Sir, Madam, we are just on this. On the legality of the impugn order of the learned single judge. All right, we'll not make comment, but obviously we'll say that it's only the representation. Wrongly or rightly, you have already given the NOC, LPC. If you have wrongly issued the LPC, cancel it.
Lordship,
Who is stopping you?
Page 19, my affidavit in page 19 also.
19.
Commissioner to-
Affidavit.
Yes.
Page 19. Stop issuance of bills for RF
Yes.
areas, if any, so any.
Lordship, the LPCs, if any issued with a forest reserve area, be also cancelled under intimation to DFO concerned. And whereas as per so and so, there cannot be non-forestry or other activities in the reserve forest and wildlife sanctuary area respectively. The Deputy Commissioners does not have any jurisdiction or authority to issue LPC to
Okay.
government. Lordship.
My lord, see,
This is there, and then
they've
the
issued already in 2021.
and
Shall be void ab initio.
yes,
That's why, my lord, this particular order, my lord,
Hmm.
that is for the area which falls within the reserve forest area,
Hmm.
my lord. Now, my case is something, my lord, how we can come to the conclusion that my land falls under the reserve forest area.
may be allowed to complete
My
just
lord.
one.
That, my lord, this
Yes.
this is the case, my lord. My case, my lord, this is the case, my lord will see that in 2005 itself,
No.
there is a decision by the Deputy Commissioner pursuant to the direction passed by this Honorable Court, my lord. Now, after 20 years, again agitated matter, but even if, my lord, as rightly said, my lord, even if the Deputy Commissioner thinks that, okay, that was wrongly issued. Now, this has to be determined by giving an application, and my case is, my lord, this falls under the excluded area. This was a part of the Vad village, which was a excluded area. And my lord, if goes deep,
It's okay, we're not concerned about that.
and my lord, if goes deeply into the issue, which I have raised in the issue, this
you cannot raise this.
My lord, even raising this this particular declaration of the forest area, this self is in question. This has not been done as per the law, my lord. There is no gazette notification. There is no procedure.
We are not here to decide that.
Yes, Lord.
It's not a, we are not concerned.
Now
in this proceeding.
Yes. Now, my lord.
Yes,
my lord.
that's all. Nothing.
No, his pledge is in law.
And my lord is saying, they are saying,
We're not going to. We don't find any infirmity. But then any decision or whatever in the proceedings shall not be influenced by the observation at para 7. That's all.
My lord.
You decide. That's all.
Yes, Lord.
And even, my lord, when we file the fresh application, it has to be decided as per the governing whatever may be the rules, my lord.
No, we'll not say anything. We are considering the legality of this
And Lord,
order of the learned single judge.
Lord,
We'll not go beyond that. All right. Heard, Mr. That's all. Our Sona, learned counsel for the appellant.
Then, my lord,
And also
before
her-
my lord finally dispose, another issue, it's very, my lord, just for my submission. Learned in the first writ petition, my lord, a direction was issued by this Honorable Court directing the chief state officer. You don't go beyond the notification. Your job is to confine whether a particular person who has applied for the NOC, you have to see only whether you have fulfilled those criteria or not. My lord, subsequently, my lord, the chief state officer, whether he can go beyond the direction of the learned single judge, my lord.
Issue NSC to the president on fulfilling all the requisites stipulated in notification. That is 7/1/2021.
My lord.
Further, Director NSN is at liberty to make verification before issuing NOC if necessary by consulting so and so, so and so.
My lord.
Same direction. All right.
Then one issue, my lord, issue is
Then Lordship,
requirement
I
is, my
said
lord.
No, no, this, in view of the page 19 of the affidavit, where the Deputy Commissioner has declared the LPC knowingly or unknowingly issued to the individuals, which falls under the forest area, according to the, which falls under forest.
Yes.
Therefore, a wildlife sanctuary, I mean, it has been declared void ab initio. So you challenge that. You have received
But
that.
not my LPC has been cancelled, my lord, as on today. That
No.
is for the area which falls within the forest area. My lord.
They are saying that yours also falls.
My lord.
It's very much false. We
My
have.
lord, that is the question who that
He
is
has said
my lord, that it has to be adjudicated. 2005 already.
you challenge her.
Given the map also.
Well, with that, it can be.
See, you are aggrieved simply on the rejection on the ground that there is a complaint or the representation for cancellation.
Yes.
So NOC could not be issued. That's all. Heard Mr. Arsona, learned counsel. That's all.
Yes.
Learned counsel for the
Just one
appellant.
If,
Will not
if this
go further. If we go further, if we go whole hog, many things will come out.
I have raised so many issues, my lord, here.
We're just saying that we cannot in this proceeding.
50,000 square meter, the LPC can.
Who is stopping you? Cancel it.
Yes, Lordship.
Cancel it.
We have said
Immediately cancel it.
We have said so.
But your page 19 doesn't indicate whether it's land or not. Whether you have cancelled, whether declared that this thing, it's a general order.
Lordship,
It doesn't show his land.
Lordship, because of the pendency of the cases, they are not being able to do it.
Do it.
Otherwise, Lordship is.
Well,
the
I will-
process.
I will-
Do it.
We will take them to the appropriate authority.
It's in the process, Lordship.
Another good job for lawyers.
Yes, my lord.
All right. And as well as Mr. And also had MSG at the London additional senior government advocate for state respondents. Only state respondents.
Yes, Lordship.
Yes, my lord.
Here in this proposal.
On
Chief
behalf-
State Officer and my lord Forest Department.
1 and 2, Lordship.
Okay.
Because my lord, Forest has been implemented only by the order passed by this honorable court.
This intercourt appeal is directed against the order dated 07/03/2023 passed by the learned single judge in WPC 215 of 2021, whereby the writ petition filed by the appellant was dismissed. List of the appellant approached this court. Next para, being aggrieved of the letter dated, aggrieved by the letter dated 06/04/2021, issued by the Chief State Officer, Government of Arunachal Pradesh, Eternal Weber, the petitioner, the NOC sought for by the petitioner, appellant. No objections are to be within record. NOC sought for by the petitioner to undertake earth cutting at what village? Lower village. Itanagar, within bracket, earlier known as Lor Putung village, bracket close, near Ganga market, was rejected. Basically, rejected. Please stop. Next para. The projected case of the petitioner is that he has a private plot of land measuring 50 square meters, 50,000 square meters, located at Lor village area, Itanor, for which a land possession certificate was issued by the Deputy Commissioner, Papumpare District, UPA, on 10/12/20, wide dated 10/12/2025. The having desirous of constructing an approach road to connect his plot of land at Lor village, Itanor, with the main road, the petitioner sought for, petitioner has sought for no objection certificate from the Chief Estate Officer, in terms of the relevant notifications list of by impugn letter dated where is 84, 81, sorry, 84, 606 04/2021.
Yes, my lord.
The
My lord,
state officer, the chief state officer, ADM, Eternal Capital Complex, Eternal,
49
has denied the issuance of NOC as sought for petitioner inter alia on the ground that a representation addressed to the Deputy Commissioner, Papumpare, has been submitted by Deputy Chief Wildlife Warden, Eternal Wildlife Division, Naharlagan, seeking cancellation of the LPC dated 10/12/2005 issued to the appellant, stating that no NOC was obtained from the Eternal Wildlife Sanctuary authorities, which is a clear violation of Wildlife Protection Act 1972 and Forest Conservation Act 1980. This stuff. The learned single judge on consideration of the impugn letter dated 06/04/2021 has dismissed the writ petition being devoid of merit by an order dated 7/03/2023, which is reproduced herein under. Page 28, para 5, 6, 7, 8, and 9. Next para. Mr. arsenal and consider the appellate. After arguing, after taking several other grounds, basically, essentially confined to the submissions that the appellant is basically is aggrieved by the aggrieved of the observation made at para 7 within bracket supra para 7 by the learned single judge, wherein it is provided wherein it has been observed that you started for even if others do, it's okay. Observed, but whether the petitioner would be entitled to possess the land measuring 50,000 square meter by the LPC dated 10/12/2005 itself has come under cloud. Even if the petitioner is found to be entitled to possession of 50,000 square meters of land in terms of LPC, no construction of approach route as proposed by the petitioner can be permitted to be done, as the same would pass through a wildlife sanctuary and forest area within the meaning of Wildlife Protection Act 1972 as well as and Forest Conservation Act 1980, which is purportedly found from the implemented dated 06/04/2021 issued by the Chief State Officer. He strenuously asked that the learned single judge could not have observed the could not have made the aforesaid observation, as there is no materials on record, including the impugned letter issued by the Chief State Officer, to show that the land for which the land of the petitioner for which the LPC has been issued validly does not indicate that the same falls within the wildlife sanctuary and forest area. This stuff. He further submits that even if assuming that there is a complaint of the authorities of wildlife sanctuary, until the LPC validly issued in favor of the petitioner is cancelled, no conclusion could have been drawn that the land of the petitioner falls under the forest under wildlife sanctuary or forest area. Next paragraph. On the other hand, MSG at the Learned, additional senior government advocate for the respondents, while referring to the affidavit in opposition filed on behalf of the state respondents, submits that the area, the land which the petitioner claims to be under possession by virtue of the LPC issued on 10/12/2005 falls under the wildlife sanctuary and the forest area. List of. She submits that the LPC issued to the individuals. LPC issued for the land to the individuals which falls under the forest, wildlife sanctuary and the forest area have already been declared void ab initio by the Deputy Commissioner, Eternal Capital Region, by an order dated 07/12/2021. Next, therefore, the LPC issued wrongly to the petitioner also extends what do you call it? Also extends cancelled.
Yes, cancel.
Extends cancel of having been declared void ab initio. Mr. Next paragraph. We have considered the submissions of learned counsel for the parties and also perused the materials available in the court, including the order, impugned order that is 07/03/2020 passed by the learned single judge. Next paragraph. As recorded here in above, the letter impugned in the writ petition that is 06/04/2021 issued to the petition by the Chief Estate Officer rejecting the denying the issuance of no objection certificate for construction of an approach route to connect this plot of land at Lower Village is on the ground that the authorities of the wildlife sanctuary has filed an objection before the Deputy Commissioner Papumpare to cancel the NOC issued to the NOC dated 10/12/2005 issued to the petitioner. List of. And it also reflects that the process for initiation to cancel the continue, which indicates that, which reflects that the process for cancellation of the LPC dated 10/12/2005 issued to the petitioners by the Deputy Commissioner on the ground of not obtaining any NOC from the Eternal Wildlife Sanctuary. The authorities of the Eternal Wildlife Sanctuary, in violation of the Wildlife Protection Act 1972 and Forest Conservation Act 1982, is under process. List of the records placed by the state authorities, particularly the order dated 07/12/2021 issued by the Deputy Commissioner Papumpare, the Deputy Commissioner Eternal Capital Region, also indicates that the recommendation of land allotment and LPCs issued by the Deputy Commissioner in respect of reserve forest and wildlife sanctuary area shall be void ab initio. Thus, the LPCs issued by the Deputy Commissioner for a land to the individuals for a land which falls under the wildlife sanctuary, eternal wildlife sanctuary. No, reserve forest and wildlife sanctuary is then automatically cancelled. List of that's all. Having considered above, whereof the considered view that when unable to accept, we find, sorry, having considered above, we find no infirmity in the order of learned single judge, in the order dated so and so, passed by learned single judge in WPC 215 of 2021. According to writ petition. No, as we and as the learned single judge has recorded its finding based on the record as reflected clearly in the impugned letter dated 06/04/2021 and issued by the chief state officer. Thus, we would not have any other view than the view, and we would not have any other observation than the observation made by the learned single judge, which is based on records list of. However, considering that there's no the respondent authorities. However, considering that no materials is placed on record by the parties so as to discern that whether the LPC dated 10/12/2005 issued in favor of the petition has been cancelled or not, except a general order that is 7/12/2021 declaring the LPCs issued by the Deputy Commissioner for the land falls under the Forest Department, wildlife sanctuary and forest area to be void ab initio, we deem it appropriate to grant liberty to the appellant to recourse to appropriate remedy. A request to avail the appropriate remedy as may be permissible under the law. It is also provided that the respondent authorities / forum, the authorities / forum shall not be influenced. Shall, in the event that the respondent, the appropriate authorities / forum request to take a decision as regards the claim of the appellant, comma, same shall be decided on its own merit and in accordance with law, without being influenced by the observation made at para 7 of the impugned order dated so and so by the learned single judge. In terms of the above observation, the representatives. No, we'll say that
Partly allowed.
accordingly, writ petition stands
Dismiss, Lord.
dismissed with the above observation.
Mother, those items, 21 and 22.
Yes.
We'll continue.
Okay.
Will continue, my lord.
No.
It is there. What do you say? What do you say? Is there urgency? Is there? It's up to you. You can continue up to 1 hour. You can hear you.
Fine, my lord. Then that's fine.
But provided you just don't elasticize it.
No, the last item can be taken up. Hearing 22. Last item.
Other side.
Other side ready?
Yes, Mr. Ratan is there.
Okay, then we'll take it up 21.
Yes, ma'am.
For till
it will take only 20 minutes, most probably. From both sides, it will take 20 minutes.
20 minutes.
Maximum. Hostile discrimination.
Let's see. We'll see.
Yes.
Let's see.
Well, this item number 20 may kindly be fixed next next DV.
20, which for state? Which for respondent?
Madam Ate was there.
10,000 square meter.
Correct. 10,000.
10,000. It's allotted to the police department.
No, that
police
is
station is there.
After.
If you have not legally donated, you donate it now. It's already donated.
That is another periphery where we have to take a roundabout.
You impress upon the appellant.
Let me advise.
Good use your good thing.
I need to speak to them, but then I need instructions.
Good your use your good person.
I will do that.
On the prayer of Mr. Tititara, learned senior counsel for the appellant, let this matter be listed after 2 weeks.
Next week.
After a week.
After a week.
After a week. You are there in item 20.
Mrs. Ate is there.
MS.
I'll communicate her.
Item number 21.
This unique hostile discrimination within the multitasking staff, the skilled and unskilled. Now, these petitioners, they were appointed in 2003 and 2003 as a unskilled daily labor. And because of their nitty-gritty for performing dutiful job, they were further promoted to skilled, to skilled. And then what had happened is, have this office memorandum at page 37, 9/1/2012. Page 37, It says, my lord, that common seniority list must be maintained for the multitasking staff.
Just wait. Page 28.
37, my lord.
37.
This is the office memorandum dated 9th January 2012. That is for the common. My lord will kindly come to the guidelines. B. A. All department stroke appointing authorities should maintain a common list register of serving contingent staff, which invariably should include both skilled and unskilled serving contingent staff in their department, stroke officers in order of their date of joining as such staff. Now, the B says, absorption to regular post stroke service of the contingent staff who have rendered 20 years as contingent staff in terms of recruitment rules and notified wide F file number AR 175 stroke so and so dated 27 January 2011 should be based purely and strictly in the order of common seniority list register of the serving skilled and unskilled contingent staff. Now, further in the C, it says 20% of the unreserved post in the grade cadre should be normally filled on the basis of common seniority list and in case of non-availability of general category candidates in the seniority list, the vacancy may be filled. So this is how they maintain the common seniority list of both skilled and the unskilled. Miller. Now, my lord, what had happened? Thereafter, they have framed a recruitment rule in 2019 and 2021. My lord. So these two impugned recruitment rules are put into challenge before this honorable court because it creates a hostile discrimination between the skilled and the unskilled who are daily laborers. My lord. Now, there cannot be such kind of discrimination. My lord. So then kindly, my lord will kindly have the page 41. That is the first recruitment rule is page 41 is notifications in exercise of power conferred proviso Article 309 of the Constitution of India and in separation of common recruitment rules the post of multitasking staff, MTS notified wide OM dated so and so, except as respect things done or omitted to be done before such separations. The Governor of Arunachal Pradesh is pleased to make the following rules to regulate the method of recruitment to the post of multitasking duty, daftari, barber, cook, washerman, cobbler, and equivalent post. My lord will only mark the word equivalent post. What I am trying to please my lord is the word equivalent post, because the skill and unskilled, my lord, the only difference of a salary is 1,000 rupees, my lord. Even in the 2025 notification also, my lord, the unskilled will get 25,000 something and 24,000, and the skill will get 25,000, my lord. Whereas the status of both these employees are daily laborers only, my lord. Nothing else.
But there's a difference, maybe 1 rupee. For skill, it's higher.
Because that is the magnanimity shown by the visors who are sitting in the executives, my lord.
So we'll
because there cannot be. My lord, kindly see.
Unless we consider them timid, we'll have to accept the wise decision.
My lord, let me draw an analogy.
Then you first tell us whether the decision is by the wise man or wise. Wiser.
The wiser beyond
the timid.
Wiser beyond their reach, because it has gone to the celestial body, where we cannot understand whether they have really read through the rules book or not.
Then in that case, they cannot be called as wiser. Wise.
That is one way of putting, my lord.
Yes.
So my lord, kindly see. They said an equivalent post in various departments under the government of Arunachal Pradesh.
No,
that is their objective. Equivalent post.
Multitasking post.
Yes.
Like deputy, barber, cook, washerman, cobbler. The equivalent post here, phraseology is to the post which is equivalent to this post only.
These equivalent daily laborers?
No, it doesn't.
My lord, our appointment, we are daily laborers. Daily laborers, my lord, on wage base, my lord. So therefore, we cannot be put into the scheme of a different definition. And that will be only a kind of differentiation in the form of hostility, my lord, and which is not been well appreciated
So
by
let us
the various
take
judicial presidents.
let us take an example.
Correct, my lord.
Chief Justice and a few new judges. What is the difference?
Difference is he is a master of the roster.
That's all.
That's all.
Otherwise, as a judge, what is your main role? What is your duty?
Judicial
render
power is
justice?
same.
Yes, it's like that only. Maybe, but then
this, my lord, one matter, the same issue I have argued before the
top
Chief Justice
among
Mehta.
equals. Top among equals.
First among the equals, my lord. First among the
First
equals.
or top among the
Yes.
equals. But then
The phraseology used is first among the equals.
maybe you can call it top also.
Correct.
No issue. Likewise, skill.
Art of articulation.
Little above. Maybe you are working almost the same thing.
I am grateful. Things are
The little higher responsibility, skill, advantages.
only that administrative power, my lord. So, my lord, kindly see now in 2021 recruitment rules, my lord will have it at page.
What is the offending provision?
I'll show you, my lord. 2021, my lord, will have page 46.
46.
Yes.
Amended one.
Amended one. My lord will see this. They have used the General Arunachal Pradesh first para, my lord. The General Arunachal Service Multitasking Staff, Daftari /Pune /Chowkidar /Mali /Duck Runner /Sweeper, Kennel, Water Carrier, Wasserman, Cobbler, and equivalent post to gazetted non-military. But the word skill is omitted from here. But then, my lord will see this in short title and commencement, my lord. My lord will see, number one, these rules may be called the General Arunachal Service Multitasking Staff, the three so-and-so, main so-and-so, and equivalent post. Again, they are using the word repeatedly, my lord has seen, even in 2019 also, and even in 2021, the amendment rule, they have repeatedly used the word equivalent. Now, my lord.
No, we have to be we have to be clear.
Yes, my lord, I'm coming
See,
to that.
this equivalent post means the equivalent to the post of this mentioned post.
Correct.
Like Chowkidar, Mali, Duck Runner, because they could not put every name of the nomenclature of the post. Therefore, it should be equivalent to this post only.
That's right, correct, my lord. So what happens is, my lord, sometimes what happens even in our court itself, our Malis are pressed into the service as a cookman. In the absence, if there is a shortfall of manpower for their lordships, then what happens is similarly, my lord, those daily laborers who are on the daily wage basis, they suppose in this case, my lord, what had happened? Initially, they were also appointed as on the skill, and they were used as their services were utilized in the form of Pune, Daftari, Duck Runner, and all those things, my lord. Now, only here, because of their small one-time promotion, getting pay enhancement of 1,000 rupees, these all three of them were put into the counters of the helipad, my lord. Which is nothing, ticket issuance is nothing, is anyone can do, my lord. So therefore, same thing, my lord, will kindly have this, kindly come to 2, amendment to the schedules of the principal rules, my lord. I'm on page 46 itself, my lord. 47, 46. Two peoples, my lord, will find here. In the schedules of column 10 of para B, for the existing paras, the following shall be substituted. 50% of the vacancies shall be filled up from amongst the serving unskilled, my lord. Here, our unskilled. Skilled is omitted from here. Unskilled contingency staff / auxiliary labor corps, ALC casual labor. My lord, I comes under the definition of a casual labor. My lord will kindly have my appointment order. Daily labor. Within the minimum period, minimum 15 years of continuous service in their respective offices, the stroke departments and possessing educational qualification of class 10, the stroke ITI or equivalent pass certificate from a recognized board or institution. The selection shall be made on the recommendation of departmental selection committee on the basis of seniority, performance, punctuality, and integrity certificate. The candidate who do not possess aforesaid requisite qualifications and appointed prior to 1st June 2010. My lord, we are appointed prior to 2010, my lord. And our qualification is only class 10 pass, my lord. Kindly mark this. Shall also be considered for appointment to the post along with other candidates subject to fulfilling of requisite requirements like seniority, performance, punctuality, and integrity certificate by the aforesaid selection committee. In case, my lord, we'll see in the note, my lord. In the second paragraph, in case sufficient number of unskilled contingency staff and auxiliary labor corps, ALC casual laborers are not available within 15 years. With 15 years of continuous service, the selection committee may consider contingency staff, auxiliary labor corps, ALC casual laborers, my lord. I comes and casual labor definition is as good as a daily laborer, my lord, daily wages. With up to 12 years of continuous service. Note, my lord, here the offending thing started, my lord. The candidates who do not possess requisite educational qualification of so and so matriculation, IT or equivalent shall be written in terms of OM number, which I have referred to a while ago, 2010. 2, my lord, in the note, seniority for regular appointment to the post of multitasking shall be considered from the common seniority of all aforesaid categories maintained by the appointing authority in terms of OM number so and so. My lord, will kindly have this. Earlier, I have referred to how they maintain the common seniority list, and our name figures there. Second, Annexure 3, my lord, will see. In the memorandum is in the Annexure 3 office memorandum that my lord will find at page 37, which we have dealt it. Now, my lord, the very interesting point, contradicting with their own official action, my lord will find at page number 53, my lord, how daily wage laborers, the seniorities are maintained, my lord. I'll demonstrate this, my lord. May I please their lordship to flip on to page 53, annexure 6, my lord. My lord will kindly see. Has it, my lord, Here. The combined seniority order, my lord, that is 19B. The combined inter-se seniority list of serving daily staff, both skilled and unskilled contingency, my lord, here it figures, of Civil Aviation Department has been prepared as directed by the office memorandum number dated so and so as per the date of appointment. My lord, the petitioner number 2, Srimati Kazir Koyu stands at serial number 3. My lord will see like I am class 10 passed, skilled. Then 75, my lord, I am already, my lord, ticket counter. The job they have put me is in the ticket counter, my lord. Then my lord will see petition number 3 is at serial number 8. Kai Anna, my lord, is also, my lord will see the distinction here, peon. Even though I am a skill, but I am a peon. How they are utilizing my services. And the private respondent number 4 stands at serial number 14, my lord. Kindly see, unskilled, my lord. unskilled, he's class 12 passed, and he's posted at ALO ticket counter. This is a real-time offending, my lord. So therefore, the impugn recruitment rule, my lord, is nothing but a hostile discrimination, what I understand, my lord. Then, my lord, kindly see. Now, in this page 57, the private respondent number 4 was given promotion by holding a DPC, my lord.
In principal rule, what is the thing?
Those, Lord,
what is the difference?
Difference is this thing, Lord.
In principal rule, what was the
principal rule, my lord, will kindly come. Okay, schedule 44, my lord.
10B?
Yes, my lord.
50% of vacancies shall be filled up amongst the unskilled concerned staff who have completed 15 years of service and education. Selection shall be done by the everyone shall be registered on the basis.
That's why we are put.
Here also unskilled.
Yes.
What is the difference? Amendment 2021 and 19.
My lord will have this page 41, 90.
Mode
page
of selection.
40. Mode of selection.
Here in 2019 rules, it is by the Arunachal Pradesh Staff Selection Board. In 2021, it is by a way of a
DPC.
Departmental Selection Committee. Mode of selection is.
But it remains the same.
Yes.
It remains
from unskilled only.
Unskilled.
So what?
My lord,
you are saying that since you are holding the equivalent post,
correct?
The skill staff, what is called?
Unskilled and skilled staff.
Skill staff and have been only the skill staff, unskilled staff are being considered in the recruitment rule.
Recruitment rule, and we are left out.
Omitting you.
Yes, but this is, my lord.
So what is your next promotion post? From where you are?
I don't have any promotion.
How you are appointed?
Daily laborers on need based they recruits, my lord. Daily laborers contingency on need basis only, my lord. Suppose if somebody has served there is a shortfall of staff, regular staff, then they recruit the contingency staff.
You want that the skills should also be included.
Included.
Not only the unskilled.
Not only the unskilled.
Yes, we have directed you to bring on record.
Yes, we have
mode of
filed our-
recruitment, engagement, skill and unskilled.
Yes, madam, we have filed our additional affidavit.
Additional affidavit.
Yes.
So admittedly, for this post, as per these rules, skill are omitted. Only it will be 50% is direct recruit is something different. 50% is from the unskilled only.
Unskilled only.
Yes. Additional affidavit.
Yes, madam.
When did you file?
Filed on
11/8.
11/8.
Okay. Yes.
My lord, first of all, this unskilled and skilled contingencies, they are appointed on need based. Now, unskilled contingency staffs, their duties are given, which is equivalent to multitasking staffs, madam. We have given in page 161. Before that, in para 5, at page 160. The deponent begs to state that unskilled contingency staffs are engaged to perform duties of multitasking staffs. The nature of duties and responsibilities as per para 38, chapter 6 of Manual of Office Procedure of posts of MTS are as follows. Now, these duties, what are the type of duties? As soon as she comes to office, she should open the windows unless there are instructions to the contrary. She should dust the office tables, chairs, almirah, windows, bookshelves, whatnots, file cabinets, and other furnitures, and keep the office room clean and tidy. She should remove all waste papers for the disposal as directed by the officer or the section officer of the branch concerned. If she is attached to an officer, she should keep the pencil, sharpen, ink pots filled, and put all other articles in pin cushion, bottling paper holder, pen, scissors, so and so, so and so. She should put the above mentioned articles inside the almirah or table drawer before leaving. She should keep the slips of paper within easy reach inside the room for use of his officer and outside the use of the public. There are various, my lord. If she is attached to an officer, she should not leave before the officer has left. If has to go early, he must take prior permission of his officer or of the section officer of the branch to whom he is attached. Before leaving office, he should switch off all lights, fans, and heater, if any, and close the windows. He should fill up the water jugs, glass, so and so, so and so, so and so. Basically, the peons to do whatever office work. And in respect of skill contingencies, it is there.
50%. 50% to fill up from
Unskilled.
No. 15%.
15%
of junior secretary assistant of the LTC shall be filled up.
Yes.
Amongst the skill contingent staff from minimum 12 years of service as skilled staff in the.
My lord, the basic idea. Why? Because the nature of duties, this junior secretariat assistants, their duties, my lord, will see at page 164 of our affidavit. It is like to type all matters marked to him, to maintain a diary in the prescribed form as in appendix so and so.
Little standard duty.
A bit more standard, a little bit more standard duty.
You have the different. What is the rule?
My lord, this
DSA rule.
Rules, yes, rules.
Where it provides 15%.
That rules we have annexed, my lord, in our additional affidavit itself. My lord. In our affidavit, my lord. In our additional affidavit also. No, in our additional affidavit at page 179.
LDC.
LDC, lower division clerk cum computer operator, data entry operator, and here, if my lord will come to page 181.
Different except civil assembly.
25% from the MTS through limited departmental competitive examination.
Page
181. And 15% from skilled contingency staffs through limited departmental competitive examination. Then rest 60% by direct recruitment.
Approach MTS through limited departmental 15% skilled contingency. Yes.
Qualification plus 12%. Come to 10%.
My lord, in fact,
is also.
in fact, the whole idea was that when over qualified persons are appointed as multitasking staffs. Like even when a master's degree holder is appointed as a multitasking staff, the officers or anyone, they get uncomfortable to even let them work. This where you cannot ask a master's degree, it becomes very uncomfortable for them to ask him
Open the window,
do this multitasking jobs, my lord.
Dusting the table.
Dusting the table and all. At least they can be put to.
Yes, Mr. Tara, nothing.
My lord, while
you
saying
have a
that,
separate recruitment rule where your chances are being given.
No, my lord.
15%.
No, my lord. It is not like exactly like that.
See, mode of appointments are based on requirements. So unskilled are appointed for certain particular, nature of job. And therefore there is rules whereby the multitasking, the post like Mali, peon and grade 4, you have been, the unskilled staffs are being given provision 50% regulation or promotion.
that is promotion.
Promotion from unskilled. And for skill, as per the rules of LDC or junior secretariat assistant and other computer operator, something like that. This 2021.
2021.
Provides 15% for you.
No, that 2021, that JSC rules is 2019.
19, yes.
Same, yeah. My lord, however, while making my submission, here, in this particular case, the writ petitioners are class 10 pass. And they were senior in the, senior to the private respondent in while being appointed initially as unskilled. Now, they have been upgraded to skilled. And by doing so, they get an advantage of 1,000 rupees more than the unskilled. Here, they are now, they can compete only as to the post. Their promotional post becomes the lower division class, which requires class 12, which requires class 12. And they are class 10. They are neither now being able to be, compete for MTS, nor they are eligible to be to give the limited departmental examination because they don't possess class 12. Now their promotional scope completely blurred, has been blocked. That is what I have found out. I was expecting that this point will be raised by my senior, but he has not come to the exact point. I had to point it out. Now, therefore, this private respondent, his appointment was in the year 2023. Now, prior to...
Is anybody appearing for him?
No, my lord.
Notice has been served?
Yes, my lord.
Served, notice served?
Notice has been, I think, served that... This is just a multitasking stuff. 2023, it's been almost 3 years now. And this writ petition was filed in 2026 only. Now, these are examples where 3 petitioners, they possesses only class 10. They may not ever be given a chance for...
So, in this petition, they are not challenging the recruitment rule of this 2019?
No.
Recruitment rule for LDC, they are not challenging?
Not challenging.
They are challenging for MTS?
MTS.
So far, the education qualification concerned.
Yes.
This page 181, the lower division clerk, recruitment rules, my lord. Kindly see the column 7. It prescribes class 12 pass. We don't have.
Can help it.
Column 8.
Can help it.
No, my lord, kindly see this. Again, the upper age limit. Then we don't have 2 years period of probations, all those things we don't have.
Which one?
Page 181. And they, according to their own admission, they will consider our case from the common seniority list.
25% by promotion by MTS through limited deformation examination. We are not concerned. B, no? Huh?
Education and other qualifications required for
was certificate from a recognized board of engineering. Typing speed so and so, so and so. On his minimum 6 months diploma in computer so and so. Typing speed. This will not be required. 15 of the skill consists of through limited departmental competitive examination.
column 8, my lord. Whether age and education qualification prescribed for direct recruit will be applied in the case of promotees. Age as per so and so, education qualification class 12. For promotees, they will require, column 7 is for direct recruits. Column 8 is for
See,
promoted.
education and other qualifications required for direct recruits. It is for direct. Whether
Yes.
age and education qualification prescribed to direct recruit is in case of promotion.
Yes. Column 8.
You were supposed to say.
As per the Arunachal Pradesh, what is the age of this? What is the age?
Age is not.
Age as per Arunachal Civil Service and Civil Post upper age limit
35 years.
As amended from time to time.
35 years as of now. We are age bar. My lord, why I'm saying this? Why these two recruitment rules are hostile? Kindly have page 46 for a moment.
You are not challenging this.
We have challenged.
No. You have only 21.
No.
19 and
46 we have not challenged. Kindly come to this page.
no, are you challenging
The recruitment rule is in our favor, my lord. Kindly
no,
see.
recruitment rule of
They say that in page 46.
no, recruitment rule of this our general Arunachal service group C ministerial common lower division clerk come computer.
We are not challenging that, my lord.
Yeah.
We are not challenging that. What
Here you have been given a chance.
No, my lord, kindly come to page 46. The answer lies here, my lord. (2021) RR, 13 July, my lord. Kindly have this. Kindly come, my lord, page 46, my lord. They said, in the note, my lord will come. Note 2, my lord. Seniority for regular appointment to the post of multitasking MTS shall be considered from common seniority of all aforesaid categories maintained by the appointing authority in terms of so and so. 2022 OA, my lord will see.
Aforesaid categories.
Yes.
Unskilled.
Unskilled.
No. The common seniority list. Common seniority list, my lord, how they maintain is page 37, my lord. Kindly come.
So what do you want to say here? Are you saying that this is offense? This offense?
No.
Then
this is in my favor.
Then
why I am saying is on the basis of page 37.
which clause you are this thing felt offended?
In the 2021 recruitment rules, the word skill has been omitted.
In 19 also there is no skill.
No skill is there, but then by these OAM, my lord, my right has been accrued. Kindly see this OAM, my lord. Page 37, my lord. This, my lord, will read this. Procedure for maintaining maintenance of common seniority list for skilled and unskilled contingent staff. Regarding law. And on the basis of this OM, Lord, the common seniority list has been maintained at page 53, Lord. Common seniority list.
But there is a different recruitment regulating your service for the next higher promotion.
That is, I am graciously.
And your appointment as a skill or unskilled, from skill to you can be, you from unskilled to you can be, I mean, elevated to skill, right? Therefore, once you have given a better position, you have been provided with in a recruitment rule to be elevated further to the higher post than the MTS. And the skill are not to them.
Correct.
Therefore, MTS only, as per 19 and 20 rule.
Assuming for a moment, what is falling from their Lord, sir, is accepted. But then kindly come to page 181. Now, before these rules were framed, we were appointed as a daily laborer on wage basis, daily wage basis.
That you have not challenged.
No.
You are challenging this rule only.
That's why,
MTS.
Kindly come to this particular page 181. What we are saying is that there is no iota of truth in a legal parlance that skill and unskilled can be differentiated. Because see, my lord, why I am saying is, kindly have this, my lord, how they have page 53, my lord, will come.
There is
nature of duty which they have deployed. Kindly see, my lord. This petitioner number 2, serial number 3, my lord, class 10 pass, Pasigat ticket counter. I give you, my lord, the example. The private respondent number 4, my lord, serial number 14, he is unskilled. My lord will find unskilled. He is unskilled and he is posted in ticket counter. It makes no difference. An increase of 1,000 rupees of a salary hardly make any difference. And now coming to this page 181.
You see on top what it says there, duties entrusted.
Correct.
It doesn't say it's your job as such. Because you are either skilled or unskilled.
Now, kindly come to this, my lord. Now, these 3 petitioners, in respect of these 3 petitioners, they are nowhere when we conjointly read page 181, my lord. Because we will never get an opportunity even to sit for a limited departmental selection examination also. Because we don't have the requisite qualification, 1, in terms of column 7. In terms of column 8.
You have not challenged that. If you don't have the requisite education qualification, what can we do? It's not only 3 of you in the entire universe. There are thousands. They are in a serpentine queue in this country.
My lord, kindly have my paragraph 21.
Yes.
Paragraph 21.
Of writ petition.
Writ petition, my lord. I'll read out 2-3 paragraph, 22, 23. I said that your lordship's humble petitioner respectfully submit that the state authorities failed to apply a judicious mind while framing the Impune Recruitment Rules 2019 and the Amendment Rules 2021, purportedly in exercise of powers under the proviso to Article 309 of the Constitution of India, as the same are not guided by any sound public policy or administrative exigency. It is apparent from the Impune rules that the promotional avenues have been provided to unskilled contingent staff to the post of multitasking staff regular. No such promotional avenue has been provided for the skilled contingent staff, despite their promotion from unskilled category.
This is absolutely not correct. No such promotion has been provided skilled contingent. It is provided in the 2020 rules for LDC and the computer operator, 15%.
15, yes, my lord. But then, my lord,
this is absolutely contrary to the records.
This is what I believe, my lord. That then too, my lord,
your belief is turned out to be, what do you call it?
Bomb goes.
No, don't want to comment further.
Anyway, kindly have para 22.
You have seen it.
Yes.
There is, wrongly or rightly, there's a scope. Provision is there in some other recruitment rule.
My lord, sometimes what happens?
Yes. Continue, please.
A injured tiger is hoping on the verge of death. He will always try to create a roadmap where he can walk out safely before he dies.
But injured, but injured is insured.
Yes.
You will not be considered as that.
I request their lordship
who has
be pleased to read paragraph.
Healthy body, healthy tiger.
Correct.
Yes.
That it is most respectfully submitted, para 22, that the provisions of the Impugned Recruitment Rules 2019 and the 2021 amendment cannot be permitted to be operated in a manner resulting in manifest and hostile discrimination as they enable juniors to supersede seniors by allowing unskilled contingent staff to be promoted to Malki, which is higher post than held by the skilled contingent staff.
Yes.
Accordingly, column 10B of the schedule to the impugned rule is liable to be suitably amended to include both. This is what our main grievances is.
Yes.
To include both skilled and unskilled contingent staff, and the respondent authorities be directed to frame equitable promotion rules for the post of multitasking staff regular by providing fair and reasonable promotional avenues.
You may be correct.
In view of
provided, you may be correct, provided if it is really the hostile discrimination, if they are really drawing the same wages, if they are maybe in isolated cases, they may be entrusted to similar job, but admittedly the education qualification requires something higher. The nature of the job normally they are entrusted with is higher standard, in higher standard, and you have been provided an avenues to the higher post than the post which they have been given a chance to be promoted, like MTS, right?
That is one aspect. Kindly come to para 23.
So omission.
That is what we are seeing.
We on the other day we thought you have been excluded without there being any provision any other rule. So we find it appears to be really
that is open.
It appears to be a good case for you. Now that's precisely we wanted them to bring on record. Correct. What is the procedure
only of paragraph 22, my lord, in our paragraph 22, because although the Lower Division Clerk recruitment rules provide a certain window for us to appear the limited departmental examination, but in case of the three petitioners, my lord, they are barred by the age, barred by the class 10 educational qualifications. So they will never have in their wildest dream to even sit for the limited departmental examination.
That is your last trump card.
So that is one. And my lord, kindly come to paragraph.
Is it your trump card or your last trump card?
I do not know. Their lordship will decide. My lord will have this para 23, please.
Yes.
That the petitioner respectfully submit that the respondent authorities have acted beyond the scope of rule-making power conferred under Article 309 of the Constitution, having traveled beyond the limits of enabling statute while framing the Impugned Recruitment Rules 2019 and the Amendment Rules 2021 for the post of multitasking staff regular. My lord, I applied my mind here. A bare perusal of the Impugned rules reveals that they are inconsistent with parent statute as they treat unequals as equals by providing a double promotional avenue to the unskilled contingent staff. And first, to the skill category and thereafter to the post of MTS regular, while completely denying any further promotional avenue to the contingent staff. That, my lord, has taken a view that in view of the law recruitment rules of the lower division clerk rules, then you are stopped from making the submissions.
No,
But then, my lord,
not as
the rule has been framed in such a way, my lord, a person's fundamental right, a person's right for consider to promotion has been denied of, my lord. How rule can be framed in that manner, my lord? That is what I am beseeching their lordships to have apply a judicious mind. My lord, such rule making.
Just before that.
Yes.
That's why I say in view of the recruitment rule, where the separate recruitment rule, where you have been given promotional avenues, maybe a little lesser, maybe a little higher, but to a better post, considering that you are above them in the present job. Is not it?
Yes. Let us complete.
The unskilled has not been given the chance to be, they have not been provided avenues, promotion avenues to be considered to the higher post of LEC.
My lord, if my lord is taking that analogy, my analogy is this, because in their...
It's not analogy, it's a factual situation. It's a fact that you have been given given promotional avenues in a different and particular rule, where into a higher post than the MTS. You are operating in a different way because you are a skilled employee.
That proposition,
skill staff, they are unskilled.
That proposition,
the nomenclature itself clearly signifies and reflects that you are not in a similar position.
But my lord,
you are a different position.
But my lord, I will have to respect.
Maybe in isolated cases, as you have pointed out, skilled and unskilled have been entrusted in isolated cases in the same post to just simply been entrusted to do the job. It will not make the rule. I mean,
on this
itself make the rule.
On this debate, my lord. On this debate, I might have a little reservation to deviate from their lordships for two reasons, my lord. The first is that in their own OM, my lord, page number 37.
Not reservation. You have a full right to dissent.
Correct. my lord, kindly see in page number 37 in their own OM, they categorically says that common seniority list of skill and unskilled should be maintained for regularization of the multitasking staff.
It's a clear precatory note.
No, but that has created my rights, my lord. Number two, my lord, the documents that I have referred to, how seniority lists are maintained by the Civil Aviation Department. There, my lord, have seen the private respondent number 4 is unskilled, and he has been entrusted with the duty of a ticket counter. He is not supposed to be done there. Then, in our case, we are posted in a ticket counter. So the skilled and unskilled, my lord, they are daily laborers, my lord, daily wage laborers. Only a financial benefit of 1,000 is given because I'm senior to them. Because we did not have any promotional avenue, my lord.
1,000 is bigger number.
My lord,
for Mr. Tara, it's not even a peanut.
Chicken.
For learned senior counsel, particularly Mr. Tara, may not be even a peanut, 1,000. For others, including us, it's a huge difference in amount.
That is the
and value.
That is
huge
the greatest,
value.
That is the greatest blessing to their lordship to be in the golden case. In any case, my lord, kindly say, let me complete this particular sentence, my lord.
Yes.
A bare perusal of the impugned rules reveals that they are inconsistent with the parent statute, as they treat equals as unequal by providing a double promotional avenue to unskilled contingent staff, first to be skilled category and thereafter to the post of MTS regular, while completely denying any further promotional avenue to the skilled contingent staff. Such rulemaking is manifestly arbitrary and ultra vires, being contrary to the settled principle that when a statute prescribes a particular manner for doing an act, the same must be done only in that manner. In the aforesaid circumstances, my lord, we are making this prayer. This honorable court may be pleased to exercise its jurisdiction under 226 of the Constitution to declare the impugned recruitment rules 2019 and 21. We have challenged this.
Yes, there in the prayer also is there.
Yes, my lord, we have challenged this. So therefore, my lord, kindly have a magnanimity and kind of grace
No,
to these poor
challenge in the
fellows.
sense, challenge in the sense, which one?
Both the rules.
Both the rules, the principal rule,
As well the
1919
amended.
and
Yes.
amended
20,
rule,
21, yes.
but not the LDC.
Not the LDC. We are not challenging, my lord. So, my lord, my younger is insisting to have. What is there? No, government affidavit. My lord, this additional affidavit, government affidavit, my lord, page 122, my lord. I always respect the view of my youngers, my lord. Otherwise, they will not grow, my lord.
Basically, the instructing council has to be respected, and you have to, the senior council has to accept while arguing, you should go by the instructing council.
I'm grateful, my lord, for the kind words.
Unless they have not done
My lord will see this.
their homework. Yes,
My
page
lord, 227.
Page
122.
122.
This rule has been amended, my lord. There, what had happened is, earlier, Group C non-ministerial recruitment rules 2008, insofar as so post of chokidar, peon, dak runner, sweeper, kennel, when water carry under government of Arunachal Pradesh. Here, my lord will kindly see, after the amendment, after this mark, total marks, 340 marks, my lord, 340 marks, note, my lord. Wait. Note B, my lord. First note, my lord has seen. The note B. 25% posts shall be appointed from the serving contingent staff who have put in a minimum of 20 years and more contingent service. Now, this rule has been framed in contravention to this itself, my lord.
No, this has been superseded.
No, my lord, even then, you cannot frame a rule by curtailing someone's right for consideration of promotion. And you cannot frame a rule that really discriminates somebody, my lord. And where do we go, my lord?
This was amendment to the rules 2008.
Correct, my lord.
And then this
Earlier,
has been superseded.
My lord, the
entire rule has been superseded.
My lord, the corollary view is that when you provide this, what 25% shall be appointed from the serving contingent staff. What is this contingent staff? It's nothing but MTS, but skilled and unskilled, my lord.
It's a fait accompli because it's been superseded.
My lord, that's why, my lord,
Page 122 has been superseded.
That's
which
right.
is an amendment to Rule 2008.
That is why, my lord, I have used this, my lord, paragraph 23.
So
even
once,
paragraph 50,
once it is superseded, what remains? You cannot make the dead man alive.
Let God's wisdom be there, my lord.
Huh?
Let God's wisdom be there, my lord. Because you feel a lot of pain, my lord, when you see this kind of discrimination, especially group B, C, D staffs, I don't care. But when you appear for
Yeah, we
such
must
kind of
care.
people.
After all, they are also human beings. They are
No,
also.
they are human beings, but then, say, my lord, in our judicial, in our
Rather, we should care
the
for
poor
them.
always suffers, my lord.
We should not bother about the rich man, but we should care about them.
And the unfortunate part of the human life is that the poor always suffers. And this is beyond the concept of humanity.
Then why was saying that you don't care about the Group C, Group
No,
B, Group C? Why you were saying so?
Therefore, my lord, just I have a small 2-3 things to say, my lord.
You said 20 minutes.
Yes, sir. I finished, my lord.
It is more than 1 hour.
My lord,
And out of this more than 1 hour, Mr. Additional Advocate General has taken 2 minutes only.
no, additional AG has taken 15 minutes. My lord, I just, whether it may be correct proposition or not, my lord, Ajit Singh 2 judgment I am relying.
Yes.
On the proposition that Article 14 and 16(1) are closely connected. They deal with individual rights of person. There is a fundamental right to equality of opportunity in the matter of promotion, ensuring that each individual who is eligible and in the zone of consideration has a fundamental right to be considered for promotion. Because this 2019 and 21 rules had completely cut down my promotional avenues. Because in column 7, column 8, neither I just education qualification I don't have, and even I am barred by the age, my lord, because I cannot sit. So therefore, my lord, these 2019 and 21 rules should be interfere with, so that the state respondent can frame equitable rules where both skilled and unskilled, those educational qualifications, those who do not have the requisite education qualification and age bar, my lord. Ajit Singh 2, my lord, the judgment 1997, my lord, no 7 SSC 209, my lord. Para 22, I am relying, my lord.
You give that.
Yes, my lord, I'll give that.
With the paragraph.
Because, my lord,
but
in Badrinath case also, my lord, after Ajit
present
Singh.
proceedings,
Yes, my lord.
I think we're not considering the prohibition of or right to consider for promotion. We are here whether the particular rule, we're considering the violation of the rule or the constitution, whether it offends the constitution.
No, that is, but that aspect is there.
That we are hearing you, or in fact we have heard you.
My lord will kindly apply mine to one aspect of this matter as to whether, classifying in a hostile manner.
Are you saying that we don't apply our mind while deciding the matter?
Yes, yes. No, their lordships will always apply and apply.
It tracks us.
It taxes their lordships.
Not tracks. It tracks our mind every evening, every morning, every day to decide the matter.
Something. Anyway, my lord, with this I lay my.
So never think that we don't apply our mind.
I just
maybe our views may be not palatable to the, particular the parties or individual, right? Or some lawyers may not agree to my view.
No.
But it doesn't mean that we don't. We tried our best. We decide to the best of our knowledge and ability.
Now, the second authority, I'll give the list.
Yes.
The second authorities that I rely is, my lord, on the proposition that the second authority is Food Corporation of India versus Purushottam Das Bansal 2008, my lord. On the principle that states must provide promotional avenues to prevent stagnation, my lord. So if this is the case we saw, because both the rules are hostile to me and I don't have any promotional avenues, then you cannot create.
You just give the citation.
Yes, just I am.
Write it down. First one is.
First one is
Ajit Singh 2.
Ajit Singh 2. I'll give the list.
Decision.
You have
the citation.
Citation, my lord, I'll provide. 1999 7 SSC. 209. Para 22 and 27, my lord.
Then?
And this has further been reaffirmed in right to be considered for promotion must be fair and not arbitrary. That is Badrinath 2008 SSC, page 395, paragraph 45 and 47, my lord. My lord, here it says the proposition is every officer has a right to be considered for promotion under Article 16 to a higher post subject to eligibility. It is not mere consideration for promotion that is important, but consideration must be fair according to established principle governing service jurisprudence. Then it summarizes that, para 47 summarizes that the legal position that right to be considered for promotion is a fundamental right. Then, my lord, I am relying on EP Royapa 1974. I'll provide this, my lord, all the paragraph.
Why all this judgment is required? You just read you just relay that thing.
My lord, that food corporation I am relying.
You just read the McDowell's. McDowell's, and the latest would be 2017, Sarah Banu. That's all.
No, but then
That's
again,
all.
my lord,
Or this is decision which you are relying. I'm not saying it's a settled proposition. Just to apply our mind to the case you have, the lease you have brought before us.
FCI versus.
This will not help us.
Yes. FCI versus Purushottam 2008 5 SCC, page 100, paragraph 9, then paragraph 12, my lord. Thus, I am relying. It is often said, my lord.
It's okay. We'll go through.
Yes.
We're not dictating.
So then, my lord, see, my lord has referred to those two decisions, which I am yet to lay my hand properly on this, but I had a glance. But then,
No, it says nothing.
my lord,
It said how.
My lord,
And how the enactment act and rules are, on what ground the constitutionality of the rules or the act can be challenged.
Can be challenged, that I am aware.
In Sarah Banu, this has been the scope. Earlier there were only two grounds.
Correct.
Now, third ground has been the scope of that two grounds has been enlarged, where it says if it is manifest. There is a manifest arbitrariness.
Correct.
That's all.
That's correct. So, my lord, I am concluding with Madison versus Marwari 1863. One, this court will apply the power of judicial review, which has been held by the US Apex Court. From there, we have drawn the power of judicial review. We're grateful, my lord.
Okay, there are certain areas, certain least we can enlarge our scope of the jurisdiction, but it is something you are challenging the bias of the rule.
Correct.
Enacted under the 309.
309.
So scope will be little limited.
I understand, my lord, but then,
my lord,
yes.
Just a little clarification. My lord, this recruitment rule for MTS, it is not neither a proportional post, my lord. It is a post for it is a regularization from amongst the unskilled. My lord, the very entry of a person, whether as a skilled or unskilled, these are on need-based basis without any selection process. They continue in service. The government has taken, because of their continuing in service for certain long period, why not regularize them? So in that process, what is required in the case of MTS from amongst unskilled persons, because their nature of jobs, what they have to perform, we don't need a very highly educated persons to be absorbed as a regularized MTS, my lord. That whether, my lord, in this writ petition, my lord will decide whether the government can frame such a rule or not. We need persons to fill up the post of MPS who are not that much qualified, only who are sincere, punctual, and good. That as in the amendment rule, the qualifications is there, my lord.
Okay.
And secondly, my lord, I have just one citation. Only one citation, one paragraph.
I could also say.
Which says what?
Prayer? When is the prayer here?
2025.
No.
It's online.
That I have not done.
My lord, Jamon KK 2025 SCC online 7 para 36, only one paragraph. We hasten to add that whether or not the action of the employer to exclude an aspirant from the process of selection on the ground that either he is overqualified for a particular post or has qualifications which being over and above what is ordained by statutory rules or rules framed under the provision. Para 36. 36.
36.
Yes, ma'am. Only one paragraph. We are hastened to add that whether or not the action of the employer to exclude an aspirant from the process of selection on the ground that either he is overqualified for a particular post or has qualifications which being over and above what is ordained by a statutory rule or rules framed under the proviso to Rule 309 of the Constitution does not match the qualification especially required. It just has to be decided considering the rules governing the selection, the qualification prescribed, the nature of duties to be performed, the nature of service to be rendered, and a host of other factors. It has to be remembered that at times the employers need to have the right people at the right place, and not always the higher qualified has to be considered. We know that the decision holding that overqualification cannot be a disqualification, since such an approach amounts to discouraging the acquisition of qualifications on the one hand, and on the other, such an approach could be seen as arbitrary, discriminatory, and not in a national interest. However, this principle cannot be put in a straitjacket imposing rigid or inflexible rules or norms. Lack of public employment opportunities in sufficient numbers may force even a master's degree to hold and apply for the job of a peon. But if he is appointed upon his application being favorably considered, what happens to the aspirants who have not had the means of pursuing the study beyond the 12th standard? Do they remain unemployed forever? If all the majority of the posts of peon are filled up by the degree holders, what happens if the master degree holders in pursuit of greener pastures leaves the post of the peon for a better and secured higher job commensurate with his qualification after a couple of years? Does it not, in such a case, burden the public exchequer by requiring the employer to initiate a fresh selection process? Is not the state, as a model employer, obliged to ensure that the posts of peon are filled up only by those having the basic qualification and not by overqualified candidates for subserving the common good? Does not the state have the obligation to strive, ensure, and that all citizens have adequate means of livelihood? These are questions which no court can afford to ignore. We end by saying that each case that comes before the court has to be decided on its own particular facts and the problem that is present for resolution, and that there can be no universally accepted rule that every time a higher qualified candidate is to be preferred to a candidate who matches the essential qualification required for the post. My lord, basically, for the lower category of posts, we don't need higher. Now, this rule under challenge, we have framed it for this particular purpose. Maybe while doing so, these petitioners are being deprived, but that cannot make the rule bad.
Yes, we have division, single bench also.
Yes, ma'am. Obvious. That's why, even if they have been deprived, that cannot make the rule bad itself bad.
No, that's why I'm saying there is a separate rule providing promotional avenues.
Yes.
That will regulate their case.
Yes, ma'am.
And this, you said
citation number कितना था? 2025 SCC online.
2025. This is for
online.
Group MTS. I'm saying that
711.
is not challenging Group T, LDC.
Jamon.
Page 180.
Jamon.
LD was a good. Yes. So they are challenging that this rule. They have been omitted. So you provide the
Yes, my younger is doing.
3 judgment,
Correct.
which you have relied initially,
Initially.
not other one.
Fine.
We'll go through the other judgment,
Legitimate expectation.
which we may find.
But one judgment, allow me to add one judgment on legitimate
Sir,
expectation.
that cannot be a ground for declaring the rule unconstitutional. That is what
That's
we
fine.
are truly afraid. We'll pass down.
Yes.
You just right. Heard Mr. T.T. Tara, learned senior counsel, assisted by Mr. G. Bam, learned counsel for the petitioners, and also heard Mr. Enderton. We'll pass the order. Not CA.
Please, Lordship.
Yes.
Lordship, I may be allowed to withdraw item number 1. Some vital documents has been misplaced. So I'm filing it.
More vital documents.
Lordship,
Mr. K. Learned counsel for the petitioner submits that he may be allowed to withdraw this petition with the liberty to file a fresh. MSP Pang Learned State Council is present. Accordingly, representation stands closed on withdrawal with liberty as prayed for.
Lordship, still I'm filing it today again.
Obliged, Your Lordship.
Deeply obliged.
May I, Your Lordship? Lordship, I beg to mention item number 13, Your Lordship.
13?
Yes, in this matter, we are supposed to, we have not received our paravise reply. I'm for respondent number 1, 2, and 3.
Which for petitioner?
I'm
okay. As prayed for by MS. No. MS people Learned State Council praise for and is granted further 3 weeks time to file affidavit in opposition. Mr.
T. Nega.
T. Nega, Learned Council for the petitioners is present. You are also there.
Yes, I am for the respondent group. 5, 6, and 10.
Mr. T. Nega, Learned Council for the petitioners, and Mr. G. Katu, Learned Council for respondent number 5, 6, and 10.
Yes.
Are present. Yes, next.
Your Lordship, and also item number 10, Your Lordship. This matter to be listed after 3 weeks, Your Lordship.
Why?
Here also, Your Lordship, we have not received, we are yet to receive our paravise, Your Lordship.
May I please, Your Lordship? Your Lordship, I have an objection since this matter was supposed to be disposed of today in terms of the last order, Your Lordship.
What is there?
No, Your Lordship. In last order also, I asked for.
Yes, Your Lordship. Your Lordship may peruse the last order. This matter was supposed to be disposed of today. They have not filed.
Why this is listed for orders. Let it come its own turn. You be there. We'll see.
My pleasure. Lordship, I'd like to mention one writ petition, Lordship, for today.
Why?
This is for termination of pregnancy of POXO victim. Pregnancy termination of POXO victim. So medical board has to be constituted. 27 weeks already there.
Today?
Lordship, if type permit.
It's a writ petition.
Lordship, yes.
Tomorrow we'll see tomorrow.
May I, Lordship? Lordship, I beg to mention item number 5. I'm for the petitioner, Your Honor.
Yes.
And steps had been taken upon all the respondent. And respondent number 2, 1, 2, 4, and 4, 5, 7 has to file their reply, Your Honor.
You are for?
Petitioner. Petitioner.
MS?
I'm appearing on behalf of Artaku, Your Honor.
Your name, please.
Margamba, sir.
Ambassador, Learned Council, appearing on behalf of. They are supposed to file affidavit.
We are supposed to file a rejoinder,
Reply. Okay.
rejoinder, Your Honor.
You have not.
No, Your Honor. We need
Okay.
we need 3 weeks time. to file.
MS Ambassador, Land Council appearing on behalf of Mr. MSR Taku, Land Council for the petitioner. Correspondence granted further 3 weeks time to file affidavit in reply. List after 3 weeks. List the matter after 3 weeks. Yes.
Obliged.
May I, Your Lordship? I beg to mention item number 2 on behalf of Senior Counsel PD Nair.
Item 2.
Item number 2. Your Lordship, due to personal difficulties, Senior
On the
Counsel.
ground that Mr. On the ground of personal difficulty of Mr. PD Nair, learned Senior Counsel for the petitioner, Mr.
G. Taipudia, Your Lordship.
G. Taipudia,
Kindly adjourn this matter for 3 weeks, Your Lordship. And Your Lordship,
listing of the matter after 3 weeks, praise the Lord list accordingly.
and the adjournment may be continued, Your Lordship.
Huh?
And the
interim
order may be continued.
Yes.
Again, Your Lordship, item number 8. I beg to mention item number 8 on behalf of leading counsel B. Picha. Due to Your Lordship, a medical checkup, routine
Only
checkup.
Mr. On the ground that Mr. B. Picha, learned counsel by the petitioner, is undergoing medical treatment, Mr. Bam.
G.
Taipudia. Praise for adjournment of the matter. Praise allowed. List the matter after 3 weeks.
1 week, Your Lordship.
Huh?
1 week.
1 week in that case.
Again, Your Lordship, item number 9.
Same.
Same reason, Your Lordship. 3 weeks.
Respondent. Taken consent?
Yes.
Okay,
For the
Mr.
petitioner, Your Lordship.
E. Menjo for the petitioner is present. Huh?
Your Lordship, 2 weeks may be given, Your Lordship, in this. It's a 2024 matter, Your Lordship.
2 weeks?
Yes.
3 weeks?
3 weeks.
3 weeks.
Much obliged.
May I please, Lordship?
Yes.
I beg to mention item number 14.
14?
Yes, my Lord.
Fixed and part hard. Part hard matter. Yes, you are for?
I'm for petitioner.
Private respondent?
Yes.
Petitioner?
Yes.
So what do we want?
I'm for the petitioner, sir.
So what do we want?
Adjournments.
This is part hard matter. Yes, madam, you are for?
Respondent side.
So you don't have any objection?
No, I don't have any objection, my lord.
Then we'll release from the part hard. Right? Mr. MS, your name, please?
The Shrine, my lord.
The
Shrine. Shrine. SHRINE.
Shrine. Appearing on behalf of Mr. Regum Arnab.
Titopu.
Huh?
Titopu.
You are for respondent?
Yes, I'm from respondent side.
Appearing on behalf Mr. Titopu, Land Council Prime Respondent. And Mr.
Tidoko. Tidoko. Tidoko.
D-O-K-O.
D-O-K-H-O.
E-H-O. Doko. Land Council appearing on by Mr. Arnabam, Land Council petitioner. Have jointly prayed for adjournment of the matter on the ground that their respective seniors are the indisposed list of, although matter was partly heard, considering that the prayer of Land Council by the parties, let the matter be released from part hard and according as prayed for. List the matter after 3 weeks.
After 1 week.
1 week. Normally we don't release. It's okay.
Much obliged.
Mayor Lordship, I beg to mention item number 4. Leading counsel is out of station, may be listed after 1 week.
On the prayer of Ms. S. Somolan, counsel for the petitioner, list this matter after a week.
Much.
Item number 3.
Influxes.
Yes, Your Lordship.
Mr. E. Menjo.
Yes,
Learned counsel for the petitioner.
Yes.
And Mr. G. Tarak, learned standing counsel RWD, have fairly submitted that matter has become in process. Accordingly, the petition stands closed as in process.
Item number 6.
My Lordship, for respondent number 4, we have filed, my Lordship. For respondent number 2 and 3, we need some more time.
Who is for the petitioner? What is the matter about?
Tony Partin. Land compensation.
Okay. Non-appears for the petitioner on call. Affidavit in respect of respondent number 4 has been filed. Affidavit in opposition on behalf of respondent 4 has been filed. Mr. Baba, MS. No, Mr. As read for by MS K. Wang Molan, State Council, further 3 weeks' time is granted to file affidavit in opposition on behalf of respondent number
2 and 3.
2 and 3. This accordingly. You are for?
Respondent number 5.
You are not filing.
No, we haven't filed. We have
Huh?
not received any instruction from the.
Then you record the enemy. Record.
Item number 7.
In process. Matter has become in process.
Lordship, I have not yet received the respondent was supposed to file affidavit.
Affidavit? No affidavit, yes.
Yes, at least Your Lordship, 3 weeks' time may be granted, Your Lordship.
Mr.
T. Techi.
Techi.
Yes.
T.
T. Techi.
T. Techi, learned counsel for the petitioner. Your name is there?
In Coach list, not there, but
No,
in
Techi.
Wakalat Nama there is.
Tichi Itatara.
Not that one.
T. Techi.
T. Techi, yes.
Learned counsel for petitioners. Next matter. MS is spread for by MS P. Pangu, learned stand further 3 weeks' time is granted to file affidavit in opposition.
Obliged, Your Lordship.
Item number 10.
Yes, what do you want here?
Yeah, Your Lordship, we are yet to receive our
Yes, let's see the
reply, Your
file.
Lordship.
What is the matter about?
This is regard to compensation matter.
What compensation?
The compensation.
Land compensation.
Land compensation, Your Lordship. The urgency in this matter is that, Your Lordship, the private respondent who are left and right side to me, and I'm in between.
Huh?
I'm in between the private respondent, Your Lordship. They have received compensation. However, my name has not been enlisted.
So therefore, we need to know what is affidavit all about.
Your Lordship, if Your Lordship, this is a regard to public interest, Your Lord. Work is in regard to public interest. Therefore, we have not phrased for the interim prayer, Your Lord. And the
what is your interim prayer?
To state the execution of the work, Your Lordship. And
that is against the public interest.
Yes, Your Lord. Therefore, we have not stressed the interim prayer, Your Lordship. However,
the event of failure to file next day, the court shall proceed to hear and dispose on the basis of material without the affidavit of this state. Yes.
And Your Lordship, if the work is not stopped now, then the position and the safe side of the land will be changed, Your Lordship.
2 weeks.
Yes, Your Lordship.
Who has filed the affidavit?
No one has filed, Your Lordship.
No affidavit, no file on.
Oh yes, NEPCO has filed, Your Lordship.
NEPCO has nothing to do.
Yes, they have nothing to do, Your Lordship.
Who has to pay? Who has to assess?
The government, Your Lordship.
Yes, affidavit will be required.
Yes, Your Lordship.
Heard Mr. Ibam, Land Counsel for the petitioner. As a last chance, Miss MS P. Pango, Land Counsel, State Counsel,
I am also paying time.
and Mr.
45.
L. Perme, Land Counsel for respond number 4 and 5. Oh, what I said? As a last chance, both Miss MS P. Pango, Land State Counsel, and Mr. L. Perme, Land Counsel for the respondents are granted 2 weeks time to file affidavit in opposition. List after 2 weeks.
May I have a fixed date, Your Lordship?
2 weeks. Give the date.
9 September.
Yeah.
Reason is that if no affidavit is filed, it would be taken up for disposal. There was an order, last order, somewhere in March. Yes, take note of it, madam. Yes.
Okay.
Item number 11.
Here, Your Lordship, I may be granted some more time to file our affidavit.
Heard Mr. Arkoilan, counsel for the petitioner. Further 3 weeks time is granted to Mr. Wairi Ramlan, State Counsel for the response to file affidavit in opposition. Yes, next.
Item number 12.
What is the IA for?
IA is for modification or the vacation of interim order.
Yes, where is this? Objection is filed.
Yes, Your Lordship.
So why it should be modified?
Lordship,
Where is the order?
I have annexed the orders in my reply, counter affidavit.
Why not in IA?
So I have taken categorical statement saying.
It's very inconvenient. What is the ground for modification? Where is that IA? Order sought to be modified.
91 in my affidavit.
This sort of practice is not cannot be accepted. 90?
90, it starts from 91. The operating portion is 90 to 93. The writ petition was filed challenging the order notice dated 31/03/2026. However, the court has not stayed this order. The order is still operating. But the
7/4/2026.
7/4/2026.
Same is however received by Land State Council who has contained the eviction notice may pertain to land beyond the land covered by land president. Considering submission is directed, the land covered and precedent shall not be disturbed till the next date. And the appropriate interim order, however, should be reconsidered after obtaining instruction with State Council. Any instruction?
We have filed our affidavit.
Saying what? So what is the ground?
After obtaining this interim order, he has served me personally. The subsequent page number 94 is the photos that I have shown. He has demolished my property. In my entrance, he has blocked. However, then I have written complaint before the DC and lodged complaint before the police, but they have not taken any action yet.
Yes. Did you
Yes.
demolish?
The Lordship, I totally deny the allegations made by the respondent number 6 here, Your Lordship. Your Lordship, particularly this writ petition is for to challenge the impugned order passed by the Deputy Commissioner on 31/3/2026, Your Lordship. Your Lordship, I have obtained LPC in the year of 2016. And after obtaining the LPC, I have constructed four-sided this concrete boundary wall.
He said after obtaining the interim order, you demolished.
Your Lordship, actually what happened here is, Lordship.
It's a dispute between you and her, him.
Your Lordship.
Who is the applicant? You are responding here.
I'm responding.
Yes, he's the respondent in the writ petition. Yes, Your Honor.
I think we better to dispose of the entire matter.
Entire matter can be disposed of. However,
Not
Lordship,
today.
they have personally admitted in their own objection.
Not
Lordship.
not today. After a week. List for admission.
Yes, Lordship.
Because once if it has been demolished, we don't know.
Yes.
No, they have demolished.
So who is who has issued the eviction notice?
DC.
Deputy Commissioner.
Is it a government land?
No, Your Honor.
It's government land. The land belongs to the BRTA. In lieu of the land used by them, my private land they have given me the land, this property. I don't know whose land is this. They have DC, the Deputy Commissioner, after detailed verification, after carried out entire demarcation, they have given me in lieu of my land because my land has been used by the BRTA long back. So now,
in lieu of your land being used by the BRTF, given to the BRTF,
yes,
you have used this land. I mean, you have been allotted.
Yes.
allotted. I have been
Allotment, by allotment.
LPC. I have been given LPC.
How can the LPC is required? It's a
Because-
private land.
because
If it's a government land, allotment has to be given.
Initially, the land which I had my land adjacent to the BRTF land, which is being allotted by the government to the BRTF. So they have encroached over my land after detailed discussion, after series of
When you were given the allotment?
2000.
I mean the LPC?
2023.
He has been given 2016. You
yes.
don't know if his land. How can this give you an
This order has been passed after carried out the spot verification now in the 2026. Now DC knows whose land is this because he has given him and me. He said like
It's a same plot.
Same plot.
Your Honor-
No, it's not same plot. After DC, what does land management department they say is
Very interesting. After 1 week.
Your Honor, what happened here is actually, Your Honor.
Our
Yes, sir.
the applicant oblique respond number
6.
And Mr.
T. Pumbo.
Pumbo,
PUMBO. Sir. Pumbo, Your Honor. Your
Counsel for the petition of the opposite party, and as well as Mr. P. Y. Ramlan, State Council. As paid for by this, the parties let this matter be listed after 1 week for admission hearing.
Obliged.
We'll dispose it after in the admission hearing. Yes.
Item number 15.
My lord, I am for the petitioner.
So,
Your Honor, the case of the petitioner, Your Honor, I was granted a land possession certificate by the respondent number 2, dated 1/5/2023.
Yes.
Your Honor. Thereafter, Your Honor, by the impugned order dated 17/7/2023, the respondent number 2 cancel my LPC. Cancel my LPC
on the complaint of your brothers.
Yes, on the complaint of my brother. Three brothers.
Brothers, you work it out.
And Your Honor, from the perusal of the complaint, Your Honor, that complaint was never served to me. And before passing this order, I was not informed. I was not given any notice.
Your brothers.
2 brothers, they are not having any difficulties because they have not taken this, Your Honor, from the perusal of the complaint, seeing the complaint.
Where's the impugned order? Impugned order.
Impugned order is at Annexure 20, at page number.
Where is on receipt?
Annexure 7, page number 20.
Yes, what is this? What do you mean by has been, of Nipu village has been stent cancelled? As undertaking affidavit submitted by the applicant till further order. As undertaking affidavit submitted by applicant. Who is applicant?
Applicant, here is the petitioner.
Huh?
Applicant is the
You read
petitioner.
this, what is?
Your Honor, for issuance of the LPC, for applying the LPC, the petitioner applied, submitted the undertaking.
Has been stent cancelled as undertaking affidavit submitted by applicant till further. What does it mean?
Your Honor, undertaking is at, Your Honor, page number 14. Petitioner.
Notice was issued to you.
No notice was issued.
Yes. You fight it out. I mean, you discuss with your brothers, your siblings.
Demonstrate, which he has not disputed. I brought on my affidavit opposition. How, by suppressing the facts, even he has approached this honorable court. The fact which I brought by way of filing affidavit in opposition.
Whether the notice was issued before cancellation.
That part to my lord,
That is the crux only.
No
We
notice was
will
issued.
not go into who is right, who is wrong.
my lord, but my lord
See,
knows.
you may be genuine case for complaint,
My lord.
but it has to be, before once it is at least minimum notice has to be given to her.
My lord,
If it is wrongly given also.
my lord.
On that ground, you go back, we'll remand back, let the deputy committee decide.
That will be there, my lord. But my lord, here how suppression of material fact.
We'll not go into the merits, simply say that there appears to be no notice.
And my
before
lord, there is, it seems this order itself is something like that. It has been directed to surrender the LPC. It is in some form of
already
interim
cancelled.
No, it has been stent cancelled.
After cancellation, the direction is passed to surrender the LPC within 7 days.
It's cancelled. No, surrender is nothing inconsequential.
The fact remains, my lord, that area, it's our father's area, already been divided among.
Sir will observe that.
My lord.
Let the deputy commissioner decide.
Your
Who is the real owner, or who is and who is really entitled will have this thing. They'll decide. If that is the fact, we'll remand it back.
Yes, on the basis of my complaint.
Now, we'll not say anything on the merits, simply on the ground that no notice has been issued before cancellation. On that ground only, simple, short order. All right. Who is entitled, who is not entitled, that will be decided.
And my lord, because my lord, in that way, my lord, my complaint may be taken into.
Yes.
And opportunity to both the parties.
Yes.
That's all.
Okay.
Yes,
That's all.
My lord, in their complaint, 3 brothers, they
Okay,
have.
we're setting aside this order.
Yes.
Heard Mr.
T. Sunil.
T. Sunil, learned counsel for the petitioner, and also heard MS K. Wangmo, learned state counsel for respondent number 2. Which one?
Also for one.
One and one also, my lordship. 1 and 2.
1 and 2. And Mr. Arsona, learned counsel for respondent number 3 to 5.
3 to 5, man.
3, 4, and 5. Next para. Challenge made in this writ petition is to the order dated 17 July 07/2023, passed by the Deputy Commissioner, Lower Siang District, whereby the land possession certificate issued in favor of the petitioner is sought to be cancelled. Has been cancelled on the complaint of her brother, the respondent number 3, 4, and 5.
Yes,
Her
my lord.
brothers.
Yes, my lord, brothers.
List of next para. It is the Case of the petitioner. The case of the petitioner, the father, the mother, that her parents were under occupation and possession of land measuring 20,700 square meter at village Lipu, Likabal in the district of Lower Siva since 1970, which was used for cultivation. In the year 2009, mother of the petitioner has applied for land possession certificate of the aforesaid land on the ground of long possession. And not on the ground, please stop, huh? However, same could not be issued. List of after considerable period of time, the parents of the petitioner has given the aforesaid land to her, on which the petitioner started cultivation. List of in the year 2014, petitioner applied for grant of LPC, land possession certificate, in respect of aforesaid land. This is pursuant to the petitioner was no, please stop. On such application with the required documents, including undertaking by an affidavit, a notice, a public notice.
Yes.
Public notice.
Yes, public notice was issued.
Public notice was issued on 28/12/2022. Is it so?
Yes.
Thereafter, since there was no objection from any quarters, any quarter, and on completion of required formalities, the petitioner was issued the land possession certificates. On when?
On 1/5/2023.
On 1/5, where it is? By dated 01/05/2023. 23?
Yes, at page number 17.
Okay. 17. List of. How about? The Deputy Commissioner by impugn order dated 17/07/2023. Deputy Commissioner Lawrence, huh? Has cancelled the land possession certificate issued to the petitioner on the ground that on merely on receipt of the complaint made by her brothers, namely, her brothers, her three brothers, respondent number 3, 4, and 5. Here is list of. It is the contention of the land counsel for the petitioner that the land in respect of which the LPC was issued in favor of the petitioner was gifted to her by her parents, and in the year 2013, and is under continuous occupation of the petitioner, for which the land possession certificate was issued in the year 2023 after following due process for issuance of such land possession certificate. List of. The impugn order has been issued, passed without any notice to the petitioner, which violates the cardinal principle of natural justice, as the petitioner, as the deputy commissioner could not have cancelled the validly issued land possession certificate on the mere complaint of the respondents, private respondents. Who may be the brothers of the petitioner. Real brother or what?
Real
Brother, my lord.
Then
what she does is, my lord, already this entire area, this respondent number 5's area, she has again applied for the same area which has already been LPC allotted to the respondent number 5.
Your
And
Honor,
she-
schedule
wait,
10
wait,
is
wait.
also different.
She is having already 10,000 LPC, 60,000 area partition among 3 brothers, 1 daughter. Though daughter is not entitled, my lord knows that as per the customary law, but it's still 10,000 given.
No, we should not encourage.
No, my lord, my lord.
Rather, would
Now very interesting, my
discourage
lord.
this practice. We must encourage the daughters should also get.
Yes, 10,000 given, well. That's why we have encouraged, my lord. Now, my lord, already this particular area, she has suppressed the fact that this particular 20,000, this already comes under my LPC, answering respondent number 5. This was my LPC, it was issued in 2019 and 20.
Your LPC means respondent number 4, 3.
Respondent number 3, my lord. It's 2012.
We'll just say. She has already been given.
10,000, all he has LPC even for that one.
Your
Honor,
By
this is a different
suppressing,
plot of land.
that's why.
On the other hand, Mr. Arsola, learned counsel for the respondent number 3, 4, and 5
This is a fit case to
submits
dismiss
that
for suppression fact.
submits that since the petitioners petitioner and the respondents, private respondents are siblings,
My lord,
comma, the land, the land of the parents have been proportionately partitioned
yes,
among themselves,
yes.
wherein the petitioner has been
Given 10,500.
a huge chunk of land, approximately
10,500. And she has LPC
500
also.
square meter, which is under her possession with the valid LPC.
LPC also.
LPC. Please stop. The land, the area which the petitioner, no, the area of the land on which the petitioner has obtained LPC by an order dated 01, dated 01/05/2023 is the share of the respondent number
5.
5.
Mile.
Please stop. Therefore,
And for which, my lord, LPC was issued in
despite
2012.
a repeated request, when the petitioner refused to settle, a complaint was made by the private respondents before the deputy commissioner, placing all the facts listed accordingly. The LPC dated 01/05/2023 issued in favor of the petitioner has been cancelled in accordance with law. Please stop. Next para. What is your stand?
Your Honor,
It may be
That is
reported
the
back
submission.
to DC.
Next.
even the LPC of the petitioner, the boundary description is also different.
London State Council submits that in view of the disputed question of facts, matter may be remanded back to the deputy commissioner for appropriate resolution, as both the petitioner and the private response have made their respective claims and counterclaims as regards the rightful ownership of the land in question. Next para. Consider these submissions. Next para. Admittedly, an LPC in respect of land measuring. Where is the LPC? 20,700 square meters was issued in favor of the petitioner by the Deputy Commissioner, Lower Siang District, by dated 01/05/2023. Next para. It is also admitted position that the petitioner, the respondent number 3, 4, and 5 are the own brothers of the petitioner who are equally entitled for the land in respect of their parents, including the petitioner, which will please have. It is stated at the bar. It is submitted by learned counsel by the petitioner, the respondent number 3, 4, and 5, that the land of the entered property, including landed property, landed property of their parents have been equally partitioned amongst the siblings, including the petitioner,
equally, my lord, may not be there. I may some
Not
of
equally.
not equally, but she has been given a major chunk of the area.
The landed property of their parents have been partitioned amongst the siblings, including the petitioner, wherein the petitioner has been given a share of a land measuring 10,500 square meter, which is in her possession with the valid LPC without any disturbances, without any encumbrances.
Yes.
Please stop.
And my lord, with the area on which like she has surreptitiously obtained LPC, it's LPC issued on 16/4/2012. Respondent number 5, my lord.
It is also brought on record,
which is
that the LPC brought on record that LPC in respect of the same land,
my lord,
appears to have been issued in favor of the respondent number 5
my lord,
in the year 2012, which shows overlapping of the land for which different LPCs have been issued on different point of time. Please stop. At the same time, it is also noticed that please stop. Next para. It is also not in dispute that no notice whatsoever was issued to the petitioner by the Deputy Commissioner before cancellation of the LPC issued, that LPC that it's so and so. Cancellation of the LPC in favor of the petitioner, that is 01/05/2023, which in my view violates the principle of natural justice, as minimum prior notice or hearing is required to be given to the petitioner. Please stop. The reason appears to be only on the complaint made by the brothers of the petitioner, who are respondent number 3, 4, and 5 herein. Please stop. Having considered above, please stop. Considering that no notice, prior notice, or an opportunity of hearing appears to have been admittedly not been provided, issued oblique provided to the petitioner, I deem it appropriate that the impugned order, I am of the considered view that impugned order that is 17/07/2023 issued by the Deputy Commissioner Lord Sivansi, cancelling the LPC issued in favor of petitioner, it cannot be sustained. Mr. Accordingly, same is set aside. Mr. However, the matter is remanded back to the Deputy Commissioner Lower Sivansi to Lower Siang District, Likabali, to consider and decide the matter as regards the actual ownership of the land in question on the basis of the representation of the complaint not on the basis. But I said to decide. But in questions and pass appropriate orders. And if required, issue a consequential LPC to the persons who are considered, who are decided, who would be decided to be the actual ownership of the land in question.
One date may be given, both the parties may be directed to it.
The parties in the petitioner and the respondent number 4, 5, and 6.
3, 4, and 5.
3, 4, and 5. 3, 4, and 5 are directed to appear before when? Before the deputy commissioner.
My lord, I have to take the.
Where she is?
She's at Pasigat.
It's nearby only.
Will provide 20 days, 25 days.
Yes, no issue.
You decide, your brothers?
Yes.
Brothers and sisters?
September 21. Enough time, I think. 1 month. She has played the fraud, my lord, actually.
Don't. Who is younger?
Your Honor, my lord,
Well,
what my brother is submitting.
I'm the youngest one, my lord. And elder sister has taken my plot of land, my lord.
His LPC is of 30,000 square meter and my LPC is of 2,700 square meter.
21
And
September.
your elder sister,
My lord,
21 September.
Yes.
21.
my lord, generally, my lord knows immovable property as a matter of right doesn't have, my lord. But still, she has got major chunk of land, my lord. Otherwise, my lord, and she is having from the husband side also lots.
Parents are the owner of the land. It is
In Arunachal, it's like that, but then it's customarily, traditionally. But we need to, I mean.
As on today, my lord, it is not under question, my lord. But my lord, this is the law as on today. Because its constitutionality has not been put into check.
We need to come out from that.
my brother is not supporting.
Rather, the daughters should get more share than the sons.
Not getting, my lord.